right, let's get started. I'll give my team a chance to turn down the music. Great. Hi, everyone. Good morning. Welcome. My name is Crystal Okafor. I use she, her, hers pronouns. I am the special projects editor of the NYU Environmental Law Journal, ELJ, and I am thrilled to welcome you to Free the Land, a symposium on land, law, and social justice, co-sponsored by ELJ and the Center on Race and Equality in the Law, with funding support from the NYU Office of Global Inclusion. Welcome. Next slide. So Free the Land emerged as a rallying cry for 1960s Black back to the land movements that celebrated local control and cooperativism. Black thinkers homed in on the land question in the 1960s. Folks like Malcolm X reasoned that land is the basis of all freedom, justice, and equality. Frantz Fanon wrote that for a colonized people, land was the most essential value because it was land that would secure them bread and, above all else, dignity. It wasn't just thinkers who were advancing this egalitarian land ethic. There were Black doers too. Fannie Lou Hamer, the famed civil rights activist, founded her Freedom Farm Co-op, which she called a syndicate of friends and brothers, where Black folks could live on and tend land together, escaping abusive sharecropping relationships. There's also Shirley Sherrod, who launched New Communities, Inc., what is largely credited as the nation's first community land trust, paving the way for the work that so many of us do today. Next slide. This is a riveting yet conflicting history. It presents a conundrum. We know that land has long been an instrument of degradation, as evinced by settler colonialism, chattel slavery, and contemporary examples like exclusionary zoning and redlining, and of course, environmental racism. Yet land has also figured heavily in freedom dreams, whether it's the post-antebellum call for 40 acres and a mule, contemporary calls for land back, or this 1960s call to free the land. This tension is the point of departure for today's symposium. ELJ and the Center on Race and Equality in the Law have assembled a cadre of luminaries to help us, one, examine the connections between land and racial justice, two, imagine ways to decommodify land, holding it collectively for permanent affordability and shared use, and three, to plan for land return, to think through what it might look like to decolonize land today. Next slide. ELJ approaches this work with an understanding that environmental issues are often a cause and consequence of societal inequities. As a journal, we thus believe that one, it's incumbent upon us to amplify voices from frontline communities, and two, that we necessarily have to work across disciplines to address the grand challenges of the global climate crisis. ELJ has made a commitment to implementing a forward-thinking, wide-ranging mission, one that, borrowing from Jed Purdy's framing, is more than technical. You'll see this more than technical mission in our publications and events moving forward. Next slide. Before we begin today's program, I'd like to ask you to join me in a land acknowledgement. I'm currently based in New York City, which is the ancestral land of the Lenni Lenape people. Let's acknowledge the Lenape community, their elders, both past and present, as well as their future generations. ELJ also acknowledges that NYU was founded upon land marked by exclusion and erasure. For instance, Washington Square Park lies on land that was initially within Sapokanikan, a Lenape village and trading post. In the 17th and 18th centuries, Washington Square Park was within what was called the land of the Blacks, the Negro frontier, after freedom suits and land grants led to the establishment of swaths of farmland for people of African descent in Lower Manhattan. Racialized dispossession runs deep. It is our hope that by acknowledging this history, events like Free the Land can bear witness, disrupt barriers of difference, and foster the sovereignty that is the North Star for today's symposium. Next slide. That brings me to our first CLE code, sovereignty. If you are participating in today's event for continuing legal education credit, please jot down this code, sovereignty, and upload it to our evaluation form once the event adjourns. We'll provide a second code during the second half of the program. Uploading these codes is how you demonstrate your completion of today's event for the New York State courts. We also encourage you to upload questions throughout the event by hitting the Q&A button in your taskbar. Next slide. With that, I would like to pass the mic to my partner in this work, my colleague, Jason Williamson, Executive Director of the Center on Race, Inequality, and the Law. Jason.
Thanks, Crystal, and my apologies to everyone for my camera malfunction this morning. I was hoping I would have this fixed by now, but unfortunately not. The good news is that you all are not here to listen to me, so I'm going to be very quick and pass the mic so that we can get the show on the road. Crystal was gracious in describing me as a partner in her work. This is something that I and the center are extremely supportive of and excited about the symposium today. But to be clear, Crystal has been the orchestrator of most of this program, and I really appreciate all of her efforts to bring folks together and help us to have this important conversation. The Center on Race, Inequality, and the Law is relatively new to the environmental justice space, in fact, and part of why we wanted to make sure we were involved in supporting this symposium is that we'd like to be much more deliberate going forward in supporting the work of the folks that are with us today for the symposium and folks around the country who are doing work in this space. Up to this point, the center has focused primarily on the intersection of race and the criminal legal system, race and technology, race and community equity, which is to say our housing situation here in this country, transportation, infrastructure, all of the ways in which people and communities of color are alienated and oppressed in this country, and finding ways to address those inequities across all sectors of our society. And of course, environmental justice is an important piece of that work. And so we want to make sure that we are approaching this in a as holistic a way as possible. And hopefully this symposium will be sort of a launching point for the center to start working in tandem with other organizations and activists who are doing this work. So again, thanks to Crystal, thanks to the Environmental Law Journal, and thanks to all of our panelists today for joining us, and to all of you for being here to listen and learn. We're excited to get started. So with that, I'm going to pass the mic to the faculty director of the PACE Food Law Program, Margot Pollins, who is going to be the moderator for our keynote speaker this morning. Thanks.
Good morning. Oh, there I am. All right. So thank you so much to the organizers for inviting me to participate in this event. I'm so excited to hear the talk, and also just so excited that the Environmental Law Journal is going in this direction and taking on these issues. So I'm really pleased to be given the task of introducing this morning's keynote speaker. Bernadette Atuahene is a property law scholar focusing on land stolen from people in the African diaspora. She is the daughter of Ghanaian immigrants, grew up in Los Angeles, and attended UCLA College. She then earned her JD from Yale and her MPA from Harvard. After completing her graduate studies, she served as a judicial clerk at the Constitutional Court of South Africa, and then practiced as an associate at Cleary Gottlieb Steen and Hamilton in New York. She is now a law professor at IIT Chicago Kent College of Law and a research professor at the American Bar Foundation. Professor Atuahene has worked as a consultant for the World Bank and the South African Land Claims Commission. She has also directed and produced an award-winning short documentary film about one South African family's struggle to regain their land. She has been honored with a Fulbright Fellowship, Council on Foreign Relations International Affairs Fellowship, and Princeton's Law and Public Affairs Fellowship. Her first book, We Want What's Ours, Learning from South Africa's Land Restitution Programs, is based on 150 interviews that she conducted with South Africans dispossessed of their land by the colonial and apartheid governments and who received some form of compensation post-apartheid. Professor Atua Hene won a National Science Foundation award for her current project about racialized property tax administration in Detroit, which has received several accolades, including the Law and Society Association's John Hope Franklin Award for the best paper on race in 2020. In addition to publishing 2 New York Times op-eds and appearing on national news shows such as Democracy Now! And the Tavis Smiley Show to discuss her Detroit work, she's also published academic articles in journals such as the California Law Review, the Northwestern Law Review, and the Southern California Law Review. I'm so excited to hear what she has to say this morning, and I will now happily turn the microphone over to her.
There we go. Margot, thank you for that very, very kind introduction. I just want to start my comments by thanking every single person involved in making this event happen, but I need to give a special thank you to this young sister, Crystal Okafor, who got me all the way together, okay? Not part of the way together, she got me all the way together. And January has been the busiest month of my career, so that was no easy task. When they first invited me, I was so excited to come in person and give this talk. But of course, the situation as it is, I'm not able to make it with you in person. But this Zoom, we're gonna make this do what it do. We're gonna make it work, all right? So let's start up these slides. All right. As Margot mentioned, all of my work has to do with land stolen from people of the African diaspora. My first book, We Want What's Ours, Learning from South Africa's Land Restitution Program, really looks at land stolen during colonialism and apartheid and evaluates the post-apartheid government's program, their land restitution program to give this land back. And from that work, came 2 very important socio-legal concepts that will be the core of my talk today. The first is this idea of a dignity takings. And the argument in the book is to say that in certain instances, if I take something from you, the point is at the moment of compensation, it's to give you that thing back or something that's equivalent to that thing. But there are other instances where I take something from you as part of a larger strategy of dehumanization or infantilization. In those instances, I've robbed you of more than just your property, but I also robbed you of your dignity. And so I call that larger harm a dignity taking. The argument in the book goes, when this larger harm called a dignity taking has occurred, mere reparations are not enough, right? Just providing compensation for a thing taken is not enough. What's required is a more robust remedy that I call dignity restoration. And that is when you give dispossessed individuals and communities compensation for a thing taken through a process that affirms their humanity and restores their agency. So of course, South Africa was the perfect place for these concepts to arise, because when South Africa transitions from apartheid to democracy in 1994, 87% of the land was owned by whites, although they constituted less than 10% of the population. And this was a clear, unequivocal, the historical record is clear, unequivocal result of the dehumanization and infantilization of the native people. So it's just one of the clearest examples of a dignity taking. And in my interview, I interviewed a gentleman who I gave the pseudonym Mr. Richardson from a place called Kliptown. And Kliptown basically was an integrated area. And during apartheid, they had a piece of legislation called the Group Areas Act. And it basically sent everyone to their place. So whites went with whites, Zulus went with Zulus, Sutu went with Sutu, etc. And what they would do is come in, and Kliptown was actually assigned to be a white area, and Mr. Richardson was colored. And he talks about the day that they came to bulldoze the house, because that was one of the strategies of the South African government. After they removed you, they would bulldoze the house so you didn't come back. And he talks about the day when they bulldozed this house that was given to him by his father and was given to his father by his father, right? He talks about the day he saw that house bulldozed. He was on his way to be a teacher, which at the time was the highest profession that colored people could achieve. And he talks about it in terms of it wasn't just, the home that was bulldozed. He talks about it in terms of it being his dreams. He says your dreams, your aspirations, and your hope is destroyed. It was bulldozed. So sometimes it's more than just mere bricks and mortar that we have at stake. And that is the core concept behind a dignity takings, which Mr. Richardson so crisply captures in his quote there. South Africa was also the perfect place for this idea of dignity restoration to arise. Now, my work deals with land restitution programs, not only in South Africa, but I've looked at them in the US, Czech Republic, Australia, Kosovo, Romania, Baltic Republic, El Salvador, Hungary, Germany, Guatemala, Slovakia, Canada, and now I'm actually working with the government of Colombia. But what makes the South African restitution program different than all of these other restitution programs that I've studied is they actually try to achieve this larger remedy called dignity restoration. This is a quote from the first Minister of Agriculture and Land Affairs in South Africa, who says, "The struggle for dignity, equality, and a sense of belonging has been the driving force behind our work as a land claims commission." And so in my book, I look at the ways in which they succeeded and failed at this larger task of dignity restoration. Before I go further, I want to explain to you land reform in South Africa. It's really all found in Section 25 of the South African Constitution, and it's in 3 parts. The first part is land redistribution. And that's the process of giving people land not based on their ownership rights in the past, but based on their current need and ability to use the land. The second prong of the South African land reform program is land tenure reform. And that is non-whites, blacks were not allowed to own land outside of the designated areas. And so they were tenants. And so this is a process of upgrading them from tenants to owners. The third and final prong is what I studied and what we'll be talking about today, which is a land restitution program found in Section 25.7 of the South African Constitution, which says that any right and land dispossessed after 1913 you have an opportunity for equitable redress, for an equitable remedy. You might be asking yourself, why 1913? Well, because South Africa becomes a nation in 1910, and 1913 is the year that this newly founded nation passed its first act to dispossess Blacks called the Native Land Act, the Natives Land Act. All right. And so that's the constitutional provision. And so what I did in my first book is I did semi-structured interviews with over 100 people dispossessed from urban areas. I intentionally focused on urban areas because most of the literature focused on rural areas. On top of that, so that was kind of bottom up. I also did top down, doing semi-structured interviews of commission officials. But most importantly, I use ethnographic methods. I use participant observation, where I actually had an office and was inside of the Land Claims Commission itself for 9 months, integrated into their daily operations, observing what was going on from the inside out. And then, of course, secondary sources. Now, through these, again, ethnographic methods, I was able to come out from this case and I identified a phenomenon, okay? A phenomenon that I call dignity takings and dignity restoration. Now, I want to make it very clear that my methods don't allow me to generalize. Quant people, they generalize. My methods don't allow me to generalize. So what I do, this project took me 7 years to complete. So I took a deep, deep dive into this, and I came out and I identified a phenomenon. And really, it's up to other scholars to take my concepts and see whether or not that they apply in other instances, right? I can't tell you that. Other scholars have to tell you that. And that's exactly what has happened. At this point, over 30 different scholars have taken the concepts of dignity takings and dignity restoration and applied them in various situations. I'll give you some examples. Alfred Brophy looked at what the concepts and how they fit into the Tulsa race riots. I'm speaking to NYU, so your own Professor Daniel Hasselbosch wrote a brilliant piece about how these concepts fit into the property taken from loyalists during the American Revolution. It's a really beautifully written piece that you should look up. Another scholar, Carol Rose from Yale Law School, looked at how these concepts apply to the area of racially restrictive covenants. Dirk Hartog from Princeton took the concepts to see how they apply to coverture, right? The fact that women in a certain period in early America could not own property, and really interrogating how these concepts work in that particular area. My former colleague, Cesar Rosado, looks at these concepts in the area of wage theft, right? I can go on and on. But there were two particular contributions that I want to point out. But I really want to say that before I get to the two, so I need you to understand that these concepts have been looked at by lawyers, historians, sociologists, anthropologists, political scientists, education specialists, ethnomusicologists, right? So they've been taken and used by a variety of disciplines in a variety of applications, including they've been applied to indigenous people, violent conflict, criminal punishment, contract law, labor and employment, public policy, intangible property, community property, property taxes, right? The list goes on and on. And, but this is a conversation. So what happened is my initial definition of dignity takings was, as you can see here on the screen, which is when a state directly or indirectly destroys or confiscates property rights from owners or occupiers who it deems to be subperson, this is the key, without paying just compensation or without a legitimate public purpose. So in my initial definition of a dignity taking, I hewed very closely to constitutional takings. But there was a contribution by one scholar, Eva Pills from King's College London, that changed my mind. She changed my mind. Her case study, her work, she's an ethnographer, and her specialty is China, and she looks at the way in which Chinese urban areas, Chinese cities are expanding, and the consequences for rural people and their land being taken from them as a result of the expansion of cities. And what she found is that even though the Chinese government provided compensation to these rural people, they had no opportunity to protest the amount given through a court system. There was often violence involved, infantilization involved. And so she brings to the fore the fact that just because there's compensation provided, that is really of no consequence. And I think she's right about that. And so as the definitions evolved, the definition of dignity taking evolved. And now the updated definition doesn't include that piece about whether just compensation was paid. It really focuses on whether or not intentional or unintentional outcome was dehumanization or infantilization. And just as the concept of dignity takings has evolved, as all of these various scholars have engaged the terms, so has the definition of dignity restoration evolved. The original definition based on the South African case in my original book in We Want What's Ours was compensation that addresses both the economic harms and dignity deprivations involved. And its purpose is to rehabilitate dispossessed populations and, get this, reintegrate them into the fabric of society through an emphasis on process. That's clearly applicable to the South African case, but a scholar, an anthropologist, a legal anthropologist named Justin Richland. His work is so amazing. He's an anthropologist who's actually was invited by the Hopi people to sit on their Supreme Court. These anthropologists are great. All right, he's a Jewish brother who was invited by the Hopi people to sit on their Supreme Court. And he wrote a piece about a piece of land taken from the Hopi people. And in fact, this piece of land was sacred. And what the US Forest Service did is they took this sacred land and put a ski slope on top of the sacred land. Not only did they put a ski slope on top of the sacred land, but in order to make the snow, they showered the land in recycled wastewater. So as Professor Richland points out, they were literally shitting on the Hopi people's sacred site. And so what Justin Richland makes a point is he says, listen, the Hopi people don't want anything to do with reintegration into any society. What they want is separation. What they want is independence. What they want is autonomy. And that too is dignity restoration. And I said, Professor Richland, you're right. And so the definition of dignity restoration has evolved to take out that language that applied to South Africa, but doesn't apply in other places, like the instance of the Hopi people. So I took out that language of being reintegrated into society and just said that it has to really have a process that affirms their humanity and embraces their agency. And so you can see these two terms have evolved as scholars have interacted with them. And so that first project took me quite a while, and it was time well spent, because again, I was able to identify a phenomenon that other scholars show has resonance in so many different geographic areas, over so many different time periods, to so many different subject matters. So that first project was a success. And, but I was a little uncomfortable, because I told you all my work deals with land stolen from people of the African diaspora. But, I was really uncomfortable with the first project because it looked at Black people as the victims, the ones being stolen from. So I said, no. My next project, I want to look at Black people doing the stealing, okay? And so I was like, you know what? This is squatting. And we all know squatting is when people take land that they don't have a legal right, that does not belong to them. So I wanted to study using my ethnographic methods, the phenomenon of squatting. And again, you all are at NYU, so you would know the largest, most recent squatting phenomenon in US history happened on the Lower East Side of New York. But what is currently happening in terms of squatting in the city of Detroit far outpaces anything that was going on in the Lower East Side. So I came to Detroit initially to study squatting. I actually won an NSF grant and came to Detroit and started doing my research. And there's two kinds of squatters. One that I call takeovers, which is how the common, general people think about squatting. It's people who come into a piece of property who have no prior legal relationship to that property. But property scholars know that there's a second category called holdovers. And that's people who once had a legal relationship to that property, but they fell out of it. So in my case, they were people who owned the home, but got subject to tax foreclosure, and they stayed. So they were once owners, but now they were squatters. And so when I started interviewing both of those groups of people, I started realizing, like, oh my goodness, this tax foreclosure is a thing. And so I switched my project. I'm going to get back to the squatting project because that was also fascinating. But I had to switch my project to focus on the tax foreclosure crisis, because people, my neighbors, because I do ethnography, so I'm actually coming to you from the east side of Detroit. I intentionally live in a community hard hit by the property tax foreclosure crisis. I live in the 48214 zip code. And I can tell you that since 2009, 1 in 3 homes in Detroit, not properties, homes, has completed the property tax foreclosure crisis. Completed the property tax foreclosure process. We haven't seen this number of property tax foreclosures in American history since the Great Depression. We're talking about over 100,000 families. Homes have been taken from them by the government, right? So we all know mortgage foreclosures, when you don't pay your mortgage and the bank takes your home. Tax foreclosures, when you don't pay your property taxes and the bank takes your home. That's what's happening in Detroit currently. And I want to give you a sense of the scale of this problem. So here's a chart provided by Loveland to show you the number of properties that have completed the foreclosure process between 2002 and 2017. Now look at this. Every red dot here is a home that has completed the property tax foreclosure process. This is what it looks like at the neighborhood level. And this is what it looks like at the city level. As you can see, there is not one neighborhood unaffected by this property tax foreclosure crisis. I want to repeat, since 2009, 1 in 3 homes has completed the tax foreclosure crisis. So the question is, what in the world is going on in Detroit, right? What in the world is going on in Detroit? Well, part of the answer to this query is about these misbehaving banks and the predatory lending. So we know that during the Great Recession, property prices decline throughout the nation. But in Black and brown communities, they take a precipitous dive because that's where the predatory lending was most intense. As you can see, that's exactly what happens in Detroit. Property prices take a precipitous dive and they never recover. This is the very same time that Detroit is going through the largest municipal bankruptcy in US history. And so they just didn't have the staff they needed to adjust property values to reflect these new low property values, right? So a lot of people like to kind of just blame Detroit and the fact that they didn't have enough people to do this adjustment, but we need to look a couple of steps up, right? We need to look at these neoliberal policies of retrenchment that made Detroit, the fact that they didn't have enough employees to do this. And we need to look another step up to these corporations, to these banks. You know, no one has gone to jail yet for this predatory, well-documented predatory lending. All right. So let me make sure you can follow my presentation. I want to make sure each and every person understands how the property tax bill in Michigan is calculated. Okay, it's your taxable value or assessed value minus exemptions. And in Michigan, the exemptions are mostly for poverty, seniors, and veterans, times the property tax rate. Now, before I started my work, there was actually quite a bit of work done on the property tax rate in Detroit, which is one of the highest in Michigan. There was also quite a bit of work done on the taxable value or assessed value on assessment inequity, done mostly by economists at Michigan State and urban planners at the University of Michigan. But before I started doing my work, nobody really was looking at the illegality of it at all. Because it's one thing to say something's unjust, and it's a whole other thing to say it's just straight up illegal. So the Michigan State Constitution is quite clear. No property can be assessed at more than 50% of its market value. This is well backed up by case law and legislation. There's really no question. No property can be assessed at more than 50% of its market value. Other state laws, to the extent they mention assessed value, it says things like they may be uniform, fair, equal, which are all nebulous standards for a court to determine illegality. Because Michigan has a ratio, it means people like me can come in and run the numbers to determine legality, and that's precisely what we did. Our findings were shocking. What we found is that between 2009 and 2015, in each of those 7 years, anywhere between 55 and 85% of properties were being assessed in violation of the Michigan State Constitution. Let me pause for that to sink in. Up to 85% of properties in the city were being assessed in violation of the Michigan State Constitution. And when we broke that data up into what we call 5 quintiles, quintile 1 being the lowest valued homes and quintile 5 being the highest valued homes, we found that in quintile 1 and 2, 95% or more of the homes were being assessed in violation of the Michigan State Constitution. But when you got to quintile 5, it was less than 20%. So we find that the burden of these illegally inflated property taxes falls disproportionately on the homeowners with the lowest valued homes, the most vulnerable homeowners. All right, what many of you know is that Detroit goes through the largest municipal bankruptcy in US history and gets taken over by an emergency manager appointed by Governor Snyder, by Michigan's governor. But what many of you don't know is because of this rampant illegality that I've just described to you, Detroit's assessment division also gets taken over by the state of Michigan, and they only get back control at the end of 2017 because at the top of 2017, they finally complete a parcel by parcel reassessment of every single property in the city. And so we redid again how we did. And so I didn't do this assessment ratio study. An assessment ratio study is what I just showed you. It's the way you figure out if a jurisdiction is doing assessments equitably. I didn't do this second one. The University of Chicago Center for Municipal Finance did this second assessment ratio study after that 2017 fix. And what they found, the good news, I always like to start with the good news. Okay, so the good news is on average, things did get better. The bad news is, as you can see here, for the lowest valued homes, things didn't get better. Look at these red lines. Even after 2017, we have the vast majority of the lowest valued homes still being assessed in violation of the Michigan state constitution. So till this day, we have these, the property tax assessments of the lowest valued homes are still being illegally inflated. And this is what we call, so property taxes are what we call regressive. And all that means is that the lower valued homes are taxed at a higher rate than the higher valued homes. I'll say that once again. It means the lower valued homes are taxed at a higher rate than the higher valued homes. And as you can see by this chart, that's exactly what's happening in Detroit. On the left, the higher valued homes are taxed far below the Michigan constitutional level, but the lower valued homes are taxed above the Michigan state constitutional, the constitutional limit, right? And this is what we call, so property tax assessments are regressive. You'll hear me use that term. So I want to make sure you understand it. All right, so where does this all leave us? Let me tell you something. All right, so we scholars, me and some others who are deep into this, have been sounding the alarm bells, talking about the illegality, you know, talking about it all. But there was a expose done by the Detroit News. Let me tell you, these investigative journalists are brilliant. They made two power moves, right? The first was they put a number on it. So I was saying between 55 and 85% of properties were being assessed in violation of the Michigan state constitution. They're like, no, no, no. They are able to tell us with the most conservative estimates possible that between 2010 and 2016, homeowners were overtaxed by $600 million, right? And there's something about, you know, putting a number to it that just advanced the conversation. The second power move that these investigative reporters did, and I was like, I'm taking notes, okay? What they did is they created a website where you can, any homeowner in Detroit can put in their address to find out how much they individually were being overtaxed. My God, my God. This lit the city on fire. When people, it's one thing to know about an injustice, and it's a whole other thing to know about how that injustice has affected you in dollars and cents. Honey, there was a protest at City Hall. Now, I'm pretty left-leaning. I've been to lots of protests in my day, but this protest was something else. People were yelling, cut the check, cut the check, cut the damn check. You know, people were being dragged out by police. I mean, it was quite something. People were upset, rightfully so. It was as if somebody had stolen a senior's purse and the whole mob was after the culprit. And in the mind of the people, the culprit was the mayor. And so again, I'm taking notes because it's like one thing to do research and to expose an injustice, but it's another thing to figure out how to make that injustice intelligible to the average homeowner. You know, so I have to say, I can't say enough about this Detroit News expose. All right, so now in my next paper called Taxed Out, me and Christopher Berry, who's again a professor at the University of Chicago, we then wanted to know, okay, we now have a good estimate of how much was taken from the people, but we also wanted to figure out the exact impact of these illegally inflated property tax assessments on foreclosure rates. And as many of you listening know, there's lots of things that cause tax foreclosure. People are poor, a big medical bill, death, divorce, I can go on and on. There's so many variables. So the real challenge in this study was holding all those variables constant so we can measure the one variable of interest, these illegally inflated property tax assessments. We wanted to know their impact on foreclosure rates. And using the most conservative estimates possible, we are able to tell you that 10% of all tax foreclosures would not have happened but for these illegally inflated property tax assessments. And of those lowest valued homes, where I showed you that 95% or more were being assessed both before and after the 2017 fix, we're able to say that 1 in 4 of those homes would not have gone into foreclosure but for these illegally inflated property tax assessments. My God. All right, so where does that leave us? So first, we have a situation where the good people of Detroit are being subjected to these unconstitutional property tax assessments. And then when they cannot afford to pay the resulting illegally inflated property taxes, they are being foreclosed upon at rates we have not seen in American history since the Great Depression. Now, I haven't talked about step 4, and this is the most important step. All for property taxes they should not have been paying in the first place. What do I mean by that? I told you one of the exemptions is for poverty. If you live below the poverty line, you don't have to pay property taxes. And 40% of Detroiters live below the poverty line. But the point is, the city of Detroit made it so difficult to access this exemption that most Detroiters didn't know about it, number one, and those who did could not access it. And what do I mean? I mean, from little things, none of it's little, but from things like not putting the application online to more invidious things like requiring homeowners to come all the way down to City Hall, not call, not mail. They had to drive down, somehow take a bus down to City Hall, wait in line to go to the assessment office and fill out an application. And you know what happened once they filled out that application? That allowed the assessor to mail the actual application to their home. Yes, you heard me correctly. They literally had to apply in order to apply. These types of nonsensical barriers are what prevented Detroiters from accessing this exemption. And the city of Detroit only cleaned up its act when the legal dream team came in and sued them. NAACP Legal Defense Fund, ACLU of Michigan, and Deep Pockets of Covington and Burlington, DC, filed suit against the city of Detroit. It was a 2-part lawsuit, but we're only concerned with the first part, which is against the city of Detroit for obstructive administration of the poverty tax exemption. As a result of that lawsuit, again, like Crystal got me all the way together, ACLU, they got the city all the way together, okay? And so now the property tax exemption is very accessible and homeowners have access to it. But that wasn't, from the benevolence of the city, it was as a settlement to this class action lawsuit by some of the best lawyers in our nation. All right, y'all. So I just told you that after my South Africa project, I was like, I don't want to look at Black people as victims, right? Then I tell you, I came to Detroit to study squatting. I wanted to look at Black people doing the stealing. And where am I? I'm back with dignity takings and dignity restoration. I can't, they're just stealing from Black people again. So of course, these concepts are now again more relevant than ever. So what's happening in Detroit is a clear dignity takings. I need you to understand that these illegally inflated property taxes are merely the latest chapter in a longer history of racialized dispossession that is happening, has happened throughout the years, not only in Detroit, but lots of other urban areas. Okay, it starts with racially restrictive, it starts with slavery, for Black people, but racially restrictive covenants, urban racial zoning, redlining, urban renewal, block busting, predatory mortgage lending, right? And so you need to understand these illegally inflated property taxes, again, as the tail end of a larger phenomenon, of a larger instance of intergenerational structural racism. So this is without a doubt a dignity takings, a quintessential example, in fact. And so where there's a dignity restoration, where there's a dignity takings, we need dignity restoration, right? Which is putting these dispossessed individuals and communities in the driver's seat and allowing them to determine how it is that they're made whole. And so that's exactly what we are trying to do. We created the Coalition for Property Tax Justice, which is a coalition here in Detroit of about a dozen grassroots organizations who are teaming with researchers like myself, law students, lawyers, right? And so the coalition has 3 primary goals. The first is to stop these illegally inflated property taxes, which I've just made clear have gotten better, but they're still continuing today. Our second goal is to stop these ongoing foreclosures, because you wouldn't believe me when I tell you that they're still foreclosing on people, although there's this unequivocal evidence of the illegally inflated property taxes. And so what we're saying is, do not stop the foreclosure on owner-occupied homes until we can ensure that the people being foreclosed upon are actually, they haven't been charged any illegally inflated property taxes. Because when you take someone's home for tax foreclosure, that is an act of legal violence. Okay, it's an act of legal violence. that should only be exercised with extreme legal caution. And in Detroit, in place of caution, we have recklessness, extreme recklessness. And so what we're saying as a coalition is, no, we need to, before you foreclose, before you exercise this legal violence called tax foreclosure, we need to ensure that nobody was overassessed, okay? And the coalition's third and final goal is compensation. More specifically, we have identified we don't just say compensation, we're not saying reparations, we are looking for dignity restoration. So here comes the concept, yet again, right here. And what does that look like in Detroit? Well, just this past Saturday, we actually had something, the coalition teamed up with Council President Mary Sheffield, and we had something called the People's Forum. It was a wildly successful event, I am so glad to say, with over 700 Detroiters in attendance on an online virtual event. And what we did is we said, look, this is a compensation of a menu of options, right? And we said, look, did we get the menu right? Is there something that should be there, shouldn't be there? The first part of the event was presentations by, again, Council President, Congresswoman Rashida Tlaib, an affected homeowner named Sonia Bonnet, and myself doing the education. That was the first part of the event. But the second part of the event was the most important part, which is we broke up into 7 different small groups, which gave people with trained facilitators and scribes, and we put this menu of options before people. Did we get it right? What needs to be changed? What needs to be added? Right? Because what did I just say about dignity restoration? It's about putting dispossessed individuals and communities in the driver's seat and allowing them to determine how it is they're made whole. Me, Professor Atuahene, I have no business telling anybody, oh, you had a house stolen, you deserve a house. No, maybe they don't want to, they're over home ownership. Maybe they want a Section 8 voucher. Maybe they want something else. But that is the key of dignity restoration. It's about restoring assets through a process that also restores agency. And so that's what we are now trying to put these theoretical ideas into practice right here in Detroit. And we are hoping to pass this ordinance before the end of the year. So all of y'all who are praying, people, pray for us, honey, because we need prayer. I believe in prayer, okay? We need a whole lot of it by everybody, okay? So so that's what we're doing. So I could talk on and on, as you all could see, about this, but let me stop here so we can have some time for our Q&A.
So thank you so much, Professor Atuahene. That was fascinating, and I learned so much, and I'm so excited to ask you some follow-up questions. So I want to start with a question about the larger project of your work. So I'm wondering if you think that involuntary property loss, or let's just call it property theft to cut right to the point, if property theft is just an inherent feature of private property systems. And if so, is the project of your work to develop strong systems for what we do? It's gonna happen, so what do we do when it happens, and what are the processes that we have for responding? Or is part of the project also about reimagining property in a way that widespread property theft just doesn't occur in the first place? So to ask the question just a little bit more crassly, is there property without property theft? Is there truly such a thing as a fair private property regime?
Yeah, and so, this is a question that is really important for our Native brothers and sisters, right? All over the world, not just here in America. The land had to be taken from somebody.
Yeah.
It
Yeah.
had to be taken from somebody.
Yeah.
If that somebody initially who owned it doesn't own it anymore, then absolutely, right? The basis of private ownership is theft. And I think we have to deal with that. I love how Crystal opened up with a tribute and acknowledgement of the stolen land that we sit on, right? So important, not just lip service, but that is so fundamentally important. But I want to, so the answer to your question, Margot, is an emphatic yes, but I want to take it one step further. So, neoliberalism is obsessed with this idea of protecting property rights, right? Protecting property rights, but it's whose property rights are being protected? Right. And that's what we need to start. That's what we need to start the conversation. That's what I was, the South Africa project, that's exactly what I was trying to do. Because in the context of land restitution in South Africa, you know, it's about when neoliberal scholars and policymakers talk about protecting private property, it's about protecting current owners.
Right.
And I wanted to say we need to, if you want to be obsessed with protecting property rights, I'm gonna talk to you in your language, but I'm also going to say we need to be obsessed with protecting the rights of former owners as well, right? Which means
absolutely
taking seriously reparations, restitution, dignity restoration, all of it, taking all of it very seriously. So if you are truly interested in protecting private property rights, you need to be truly invested in the rights of current as well as former owners. And that's the point.
Yeah, so absolutely. But so then it is part of your project also about kind of freeing us from this obsession with private property?
Listen, I meet you where you are. You know, I'm a professor. I deal with my students, with whoever you are. I'm gonna meet you where you are. And if that's where you are, then I'll talk in your language, and I'll talk in terms of we need to protect former and current. If you're somewhere else, I'll move with you. I'll go wherever you need me to go, as long as we're making our point.
Absolutely. Okay, so I want to get into some of the details a little bit. One of the things you said towards the beginning when you were describing kind of developing the research project in South Africa was that you made this intentional choice to focus on urban areas. And there is, of course, a huge amount of literature on rural land theft and land grabs, and actually quite a robust international movement focusing primarily around peasant rights that culminated with the 2019 UN Declaration on the Rights of Peasants. Well, culminate's the wrong word. That's a one step in the movement, not an endpoint really. But of course, that's a movement that focuses on a particular category of land loss, right? Land that is a source of sustenance, land that is used for some kind of subsistence or sort of small scale market agriculture. So I'm curious, since you made that distinction and made that choice to focus on urban areas, if you think that as a sort of movement building tactic, that this is a good distinction to be making, right? Or is there, in focusing on land as a source of food, is that a distinction that unintentionally kind of distracts from the broader cause, or that might even be undermining the broader cause by sort of cordoning off this one subset of land as being more important than other land?
No. So don't misunderstand me. Nothing. One is just so when I focus on urban, it's not at all to say it's more important.
Oh no, I meant.
I hear you. It's to say it's not more important, but it was understudied.
Right.
And
Absolutely.
so I'm focusing on urban to balance the scales. Number one. Number two, because there are different needs of urban dispossession versus rural dispossession. Number two. And it's just to say, again, what we have to stop doing is treating everything like it's the same. That's a problem, because everything's not the same. And I think we're instinctively afraid of difference, right? Because when we start talking in terms of differences, then come hierarchies. One is above the other, when no, difference doesn't necessarily imply a hierarchy, one being more important than the other. We have to understand that urban and rural, there are differences, right? But there are also similarities. But the point is, we have to stop lumping everybody together, because when you lump people and things together, you miss nuance. Again, you miss the differences in the needs. You miss the differences, right? And so in general, in my work, I am about disaggregating. And I'm not afraid to disaggregate. And I don't think movements should be afraid to disaggregate.
Great. So let me ask you another disaggregation question then, since that's where we've gone with this. Can you talk about what you see as some of the key similarities and differences between property theft that occurs in the context of express appropriation along the lines of what you describe in South Africa, right, where there's kind of a specific project of we are taking land from these people and giving it to these people, versus property theft that has occurred in a pretty widespread way in this country and of course lots of other places around the world that is kind of hidden behind other kinds of legal mechanisms like tax foreclosure, but also like court-ordered partition sales and things like that. So there's clear kind of technical distinctions between these categories, but I'm curious what you see as kind of the implications of those distinctions, particularly in terms of how we approach reparations.
Yeah, and I think you've always got to, my main answer to that is you've got to follow the money, right? So in South Africa, it was, like you said, very clear. It was going from, it was going to white people, right? Like, so that is, it's not a follow the money, but in every other situation, you've got to follow the money. And that's how you figure out who's losing and who's gaining, right? So for instance, in Detroit is a great example. It's not like they're taking the foreclosed homes and give it, but you look at who's gaining, and who's gaining are investors who buy homes from the property tax foreclosure auction, and who's also gaining is Wayne County. And so you kind of got to, again, disaggregate, okay, that's who is gaining. And a lot of times it's also, again, it's the market hides a lot of the distribution that's happening, right? Because the point is, well, if you want a house from the tax foreclosure auction, anybody, right? That's the myth that we live under. Anybody can go and buy a house. Anybody, it's equal opportunity. Yet we know that, there are certain market actors better positioned to take advantage of that. And there are other market actors who are not at all positioned to take advantage of that. And so it's in the, when we make this switch to the market, it's the market that does the disguising, right? Because some people are positioned to participate and some people aren't, but the story we tell is everyone can participate in the market, right? We ignore the fact that some are better positioned than others, right? So it's like we have to highlight one piece of it and de-emphasize the other. We have to highlight the piece that, everyone can participate, everyone can buy these homes. And we have to de-emphasize the inequalities in society that make that absolutely not true.
Yeah, absolutely.
But I want to say the market is outside, in these situations, the market that's doing the work of this redistribution, but not in the way that you or I might want redistribution to happen.
Right. So that seems to really complicate how to think about reparations, right? Because what do you think? Is that when the market steps in and plays this role, there's so much obfuscating then that happens about the processes of theft that have occurred in the first place, and how to distinguish the instances, where the tax foreclosure was theft from the instances where it wasn't.
No, for instance, so first of all, Margot, I hope you all heard me when I said we need to stop talking about reparations. We need to start talking about.
Okay, sorry.
Did I not do my job here?
Sorry, dignity restoration. I was shortcutting. I apologize.
No, I'm teasing you. But that is part. So that's part, and that's not just, it's like that's the move I think we need to do. So let me just speak in very clear terms. Like in Detroit, a lot of people say, "Oh, it's nothing difficult." People say it's so difficult. No, there's nothing difficult about this. We literally, this is all numeric. It's all public data as well. Assessed value market, and so we have already, our data scientist has a list of homeowners who were assessed in violation of the Michigan Constitution. We have a list of people. So no, it's not difficult to find the people. No, we know who the people are, right? And so the point is now we need to get about the business about compensating them. And again, the process of compensation needs to restore an asset because an asset was taken. But again, it needs to be through a process that affirms humanity and agency. That's why you saw in that slide, what we're providing to people is a menu of options so they could say, they get to be in charge. Me or you don't get to be in charge, Margaret. They get to be in charge of how it is that they're made whole. But I think that what's going on, and I think that this is a bigger point about, again, the whole reparations conversation to me is so problematic because it's starting with slavery. Let's start with the property they took yesterday. Let's start there and go backward. Let's start to the stuff that's really clear. There's some stuff that's really clear. Let's start there and build our way back to slavery. But part of the strategic discursive move to shut down the conversation is to start with slavery and talking about, it's so difficult. It's so difficult if you can't figure it out. And then it shuts the conversation down altogether, such that we can't even pass, even when Democrats are in power, a proposal to even study reparations, right? We haven't even been able, again, even under Democrats, to pass a proposal, right, to even study reparations. Why? It's because this discursive move is made to say, oh, it's so difficult, it's too big. Well, that's because you're starting with slavery.
Right.
Let's build our way. Let's start with yesterday. That's my argument. Yesterday,
Yeah.
Today, because there was houses and some happened. Let's start with today, you know, and that's how we're really going to get this conversation going. And that's why, again, we need to shift, again, from this conversation about reparations to a conversation about dignity restoration, again, that really centers agency and uses its starting point as right now, and then going backwards instead of going from some indescript period to the present.
Yeah, I mean, that is, I find that very compelling. So I want to ask you one more of my questions, and then I see I have a list of audience questions here as well. I want to make sure to get to some of those. So I do hope that you're going to return to the squatting project at some point. I'm super curious about it, and I know you haven't done the research yet, so maybe this is an unfair question, but I would love for you to kind of speculate a bit or kind of share some of the hypotheses you're entering into that with. And if I could just sort of preface this with kind of the first things that came to mind for me, as someone who teaches property law, you know, one of the things that we see in the sort of the history of property law in this country is that there's lots of things that are kind of definitionally squatting, in the sense that they are kind of an individual person moving onto a piece of land and you know, becoming, you know, taking possession of it. And sometimes we call it squatting, which of course has this really negative connotation, but sometimes we call it other things, and a lot of the time it's ultimately legally sanctioned, right? So huge parts of the Western US were settled by squatting, that was where ownership was eventually legally recognized. And then of course we have the doctrine of adverse possession, which is a form of kind of legally sanctioned squatting as well in many jurisdictions. So is squatting as a legal framework something that we just apply to certain kinds of people when we, or, you know, in certain kinds of contexts? So is the framework itself bringing that often racialized bias?
I'm going to answer the first part of your question first, which is to say, all right, the squat actually was pretty far, Margot, on the squatting project. And that's what hurt a little bit so bad, you know, because I was like, had finished up interviews, and I'm going to pick it back up, but I was pretty far along. And one of the interesting things I can tell you from that project is my hypothesis going into the project was that the people who are going to be squatting, which I define as people living in a property that they have no legal title to, are going to be people who are really socially marginalized, right? Because, you know, if you see these squat houses here in Detroit, there's no windows, there's no heat, there's no water, you know, and so they are, my hypothesis where they were socially marginalized. They, you know, didn't have a grandma to go stay at grandma's house or friends to couch surf, right? And so that was my hypothesis. Margot, I could not have been more wrong.
Really?
So that was my hypothesis in my NSF grant. I was just wrong, you know, it's just like, you can be radically wrong. I was just wrong. So when I started doing the interviews, I actually found out. So one of the main questions I was asking in my interviews with squatters was to say, you know, do you feel safe, right? Because if you got in the house, anyone else can get into the house. And over and over again, oh, of course, professor, you know, my neighbors are watching my back. I'm watching my neighbor's back. Okay. So then I go to the neighbors and was like, you know, do you feel, oh yeah, you know, I said, oh, okay, I see. So actually you have to have a great deal of social capital to squat. And I found that people actually just don't squat randomly. They go back to their old neighborhood and take up a house there. And so you actually need to have deep ties to a particular geography and deep social capital within that particular space in order to squat because of safety issues. So initially, one of my interview groups was not people in shelters, but I had to add on people in shelters. So I was like, let me go interview the people in shelters and figure out why they're not squatting, because a lot of the problems with shelters is there's so many rules And so, you know, and they smell. I remember I went into one shelter, I couldn't even enter. It was no one in there, and they're just in such poor condition here in Detroit, these shelters. And so nobody wants to stay in the shelter. I went and interviewed people who were in fact staying in shelters. I said, well, why don't you, there's so many houses because there's so much vacancy in Detroit. That's why it has one of the largest squatting populations. That's why I came here to study squatting in the first place. And so I said, you know, why aren't you guys squatting? They said, what? Why would I go do that? I could die. They could kill me, you know? And so it was because of safety issues that a lot of them didn't go squat. So I was like, all right, I was just completely wrong. You need to have deep social. So that's one of my main findings so far.
That's really interesting.
So, but even more than that, the second, I shouldn't be saying all this because I haven't written it up yet. Nobody on here steal my, I'm just kidding. All right. So the second main finding has to do with who can score. So like, it's not just, so I'm creating a concept that all my work deals with dignity and property, as you can see. And so I'm creating a concept called dignity property is what I think I'm seeing here in Detroit in the squat. And what do I mean by that? It's like sometimes people own property, not because they have a legal right to the property, because based on certain dignity interests. And dignity property might not be recognized by the law, but it's recognized by neighbors. So I see lots of neighbors. It's not all squatters. It's certain squatters where they're like, yeah, that they're keeping up the lawn. They're contributing to the community. They're actually, I'm glad they're there. Right. And so, and everyone although legally they can be evicted at any moment. But as far as the neighbors are concerned, they belong there. And that is rightfully their property. And so I'm calling that, I'm playing with those concepts again. I'm still developing, but I'm calling that dignity property. Again, it's the right they have to the property is based on not a legal right, but on concepts of dignity. There are all these empty houses, right? Like, of course they can stay if they don't have somewhere to live, especially if they're contributing. So those are the ideas. And again, I can't wait. I just finished my manuscript for this property tax foreclosure book. And so as soon as I get this book done, I'm coming right back to the squatting project because it is so interesting. And I was maybe 70% of the way done, Margot, before I had to put it down. And this is the last thing I'll say about this is I had to put it down, Margot.
Right.
Because I do ethnography. So I this is not a game for me. I live here on the east side of Detroit. I live not in downtown. I picked a community on purpose, a 48214 zip code, because it was hard hit by property tax foreclosure crisis. Every day I see neighbors getting kicked out. They're leaving one by one by one. And morally, I couldn't just be studying squatters when I had information, what skill sets to do something about my neighbors who are losing their homes through this unjust and illegally inflated property taxes. So morally, although I was 70% of the way done, I had to put it down to deal with this fact that my neighbors are just being, stolen from left and right. But I will get back there.
All right, well, I'm really excited to see what you come up with in that final project. All right, so let me turn to some audience questions while the list of them is long. Let me dig into these here.
Let me see if I can answer some of these questions.
So, let me ask this question about gentrification. Gentrification is happening in so many of our cities. In the context of pushing back against gentrification and displacement, what are your thoughts on gentrification as it relates to those who don't own property, but who are being displaced when their landlord, quote, wants a new type of tenant or wants to sell?
Well, let me talk about gentrification and how it works with the property tax foreclosure crisis more generally, right? And so what we see is absolutely we need to understand this is absolutely part of gentrification, because when the question is when people, I just told you, since 2009, 1 in 3 homes, not 1 in 3 properties, 1 in 3 homes has been taken by the government through property tax foreclosure. So the question is, well, who's now coming into those homes, right? Detroit historically has had the reputation of having the highest number of Black home ownership in America, right? Because of the unions and et cetera, et cetera. And that has been the case for decades. And the other remarkable thing about Detroit is it had the distinction of being a majority homeowner city. Okay, Margot, a couple of years ago, I want to say 3 years ago, that switched. Now Detroit is a majority renter city, right? And so who's now owning these homes? Well, it's the people that purchased the homes in the tax foreclosure auction. Who are those people? Well, it's a diverse crew of people, right? But it's always people with access to capital, right? To be able to purchase these homes.
Mm-hmm.
And so what we see, who's being kicked out? Well, Detroit's an 80% Black city. You know, I can't emphasize that enough. It's an 80% Black city. And, you know, people, you know, when I was finishing up my work in South Africa, all my colleagues were like, you know, B, when are you coming back to South Africa? When are you coming back to the continent? My parents are originally from Ghana. And, you know, when you coming back home, you know? And I said, yeah, y'all. I said, Johannesburg is 80% Black and Detroit is 80% Black. I have not left the African diaspora, okay? So you have to understand that it was this majority Black city, it was Black people. We have to understand this as a racialized issue. Black people were living in these homes and now Black people are not living in these homes, okay? So gentrification is absolutely happening. I want to just say two quick things because I believe when you talk about Detroit and you don't deal directly with race, you're doing everybody a disservice. So I need to mention two studies. Number one is my own, where we basically, in Wayne County, which is the county that Detroit sits in, there are 33 municipalities, 43 municipalities, sorry. 33 of them have a supermajority of white people, 70% or more, and 3 have a supermajority of Black people, Detroit, Inkster, and Highland Park. So Black and white people don't live together here in Wayne County. I thought, you know, I'm coming from Chicago. I thought we had issues in Chicago, but these people are taking this segregation to the next level. Okay, they don't live next to each other, which is horrible for the world, but great for me as a scholar because there's such a thing as a Black and white city that I can compare in Wayne County. And so when I did that, I found that the majority Black cities are experiencing these unconstitutional tax assessments and foreclosures at a greater rate than the majority white cities, right? But in addition to that, my colleague Carlos Avendaño León and Troop Howard have got their hands on some amazing data. I don't know how they did it, but they did it. And they're able to tell us, they did a national study. They're able to tell us nationally, Blacks and Hispanics pay 10 to 13% more in property taxes for the same bundle of goods as whites, which it's equivalent to about $300 to $400 more a year annually. So I need you to understand when we talk about this property tax injustice, this is a racial justice issue that our country has not yet come to terms with. You know, it's something that we have there. You know, we are trying to start the movement here in Detroit because it's ground zero for the injustice. And we're calling the movement #Black Homes Matter to really bring attention to the fact that, again, this is a stealing of homes through foreclosure and wealth through overtaxation. That is disproportionate, again, here in Detroit, where we can see it in terms of Black people, but it's also, the data shows it's also a case for the Hispanic community. And so I just wanna round out that question to gentrification, to really centering the fact that this is a racial justice issue. And there's no two ways about it. And people try and push, no, we're not, that's not what we're doing, okay? We're not talking about this in other terms, okay? Not today.
Yeah.
Right? This is a racial justice issue. It needs to be articulated in those terms.
Yeah, absolutely. And okay, so another question on racial justice lines. We have 2 minutes left. There's a number of questions in the queue that are about.
I'm sorry, my answers are 50 million.
No, this is great. But to sort of draw together a number of these questions that deal with thinking about the challenge where particular pieces of land have been subject to multiple layers of theft, right? And here in the United States, of course, that's basically, you know, any land that has been subject to some kind of theft in the 20th century, there's at least 2 layers, right? Because you have that plus the original. How do you think about that in terms of approaching dignity restoration, and in particular in terms of, you know, balancing what are 2 different, historically different and culturally different, but parallel sets of justice issues around Indigenous rights and around justice for the Black community?
Yeah, so I have an article about this. Crystal, if you're here, if you could Google property and transitional justice. It's in the UCLA Law Review. Google it and put it in the chat for them, Crystal, if you can hear me, I don't know if you're there. But I wrote about this. So if people are interested in the article is called Property and Transitional Justice, and it deals exactly that. It talks about how at T1, you have the indigenous people of the land. At T2, you have, one indigenous group conquering another indigenous group, not indigenous, but one group, but, from the land, but from another region. At T3, you have colonialism, where, right, Europeans come in and take the land. And then T4, you have some despot coming in and taking the land and giving it to his cronies. And then the article says we're at T5. What do we do? That's what the article says, right? Like, what do we do? We have all these multiple layers of dispossession, right? It's like, well, what do we do? And that is something that there's no clear answer to that, Margot. That's something a society has to decide. And it seems to me every society has three options. Option one, which is the most taken option, the most traveled road, which is to do absolutely nothing. Okay.
Right.
Option two is the road that countries that have decided to do restitution programs is to say to pick one of the T1, T2, pick a time and try and go back to that time. That's what South Africa has done when they said everyone with the right in land after that was taken since 1913. They picked a point. And so you can do that. You can pick one of the T1 to right, and you pick a point, and then you do equitable redress based on that point. And it seems to me option three is the option that is to just scrap the whole thing and start all over, right? And so those are any society's three main options. And that's essentially what happened in Eastern Europe, right? When communism falls, they have all this land and they're trying to figure out the initial allocation, right? And so, but the point is, those are the three primary options, and society has to figure out, which one they are going to move forward with, right? And this takes us back to where we started. Most societies do nothing. And on top of doing nothing, they have this discourse of protecting private property rights, which means protecting the rights of current owners and ignoring the fact of protecting rights of former owners. So that's where we find ourselves, in the disgraceful position we find ourselves as a global community.
Well, I'm sorry to say that the organizers are telling me we need to stop now. So I'm sorry to everyone in the audience whose questions I did not get to. Bernadette, thank you so much. It was such a pleasure to speak with you. I hope I'll have the opportunity again. And I look forward to seeing your next project.
Yes, I hope, next time we will all be in person. There's so many things about in-person communication, just
yes.
The dinner and the interaction, we miss so much. And so
yeah.
I'm so thirsty to get back into,
me too.
Like, for instance, I'm wearing something by Luffy D. I have to give her a shout out, South African designer. You all didn't get to see this sartorial splendor I got going on right here, That's a result of the pandemic. Put that on your list of pandemic shortcomings. You can see Professor Atuahene's sartorial splendor with what Luffy D did for me over here. No. So anyway, thank you all. Again, I just want to give a big shout out to every single person involved in organizing this. A big, big, big shout out to Sister Crystal and Margot. A big shout out to you. Thank you. Your questions were brilliant. And this has been a wonderful conversation. Thank you so much.
Hi, everyone. Thank you so much for attending. We're now moving on to session 2. We kind of ran over, so we're not going to be taking a break. I hope that works for everyone. My name is Tanya Shajanian. I am a third year here at the law school. I'm also a managing editor at the NYU Environmental Law Journal. So I just wanted to pop in here on behalf of ELJ and thank you all for attending. We have a really great turnout today, which excites us immensely. So thank you so much for your enthusiasm. Environmentalism, as many of you are aware, has a history of being exclusionary. Legal academia is no different. However, environmental law is inherently interdisciplinary and has the potential to better serve the needs of both local communities and the larger planet by incorporating a more collaborative framework. As a law journal, ELJ is looking to re-envision what environmental legal scholarship looks like. We want to expand our platform to include not just traditional academics, but practitioners and activists whose perspectives are essential for social progress. We hope to transform the nature of environmental legal discourse by broadening both the type of work we publish and the makeup of our readership to serve larger and more holistic legal and social goals. We believe this symposium and its accompanying journal issue is one step towards doing so. The issue will be out later this year featuring articles written by our wonderful panelists, so make sure to check it out when it gets published. In addition, we believe that active recruitment and engagement are critical to reimagining traditional institutions. So consider this a call for submissions. If you believe your work would be meaningful and contribute to environmental law in some way, please visit our website to find out more about how to submit an article for consideration. We would love to hear from you. Before we move on to our highly anticipated panel discussion, I want to give a big thank you to Crystal, our special projects editor, who you met earlier. Crystal is a Root Tilden Kern Scholar and a Moelis Urban Law and Public Affairs Fellow. Crystal's background is in urban and social policy, and she came with us. She came with the symposium over a year ago and had a really clear vision for the topics and voices she wanted. She has worked tirelessly and brings her ideas to fruition, and I want to thank her on behalf of the entire journal for her amazing work. I look forward to collaborating with you, Crystal, upon graduation. Thanks so much. All right, so moving on to our panel discussion. The CLE code is solidarity. Please ask questions in the Q&A box. We really welcome active audience engagement. And moderating our panel discussion is a new member of the NYU faculty, Professor Maggie Blackhawk of the Fondue Log Band of Lake Superior, OBGY, who is an award-winning interdisciplinary scholar and teacher in the fields of constitutional law, federal Indian law, and legislation. Her recent projects examine the ways that American democracy can and should empower marginalized groups, especially outside the traditional rights and court-based frameworks. Excited to have you leading our discussion today, Professor Blackhawk. And now for our amazing panelists, joining us, we have Akila Brown from the New York City Community Land Initiative, Michael Johnson from the Mott Haven Port Morris Community Land Stewards, Satish Nori from the Legal Aid Society, Saka Yabare from the Northeast Farmers of Color Land Trust, Leo Figueroa Palond from the New School Tishman Environment and Design Center. Okay, I'll pass it to you, Professor Blackhawk. Thanks so much.
Thank you so much, Tanya, for that wonderful introduction, and to all of our organizers, including Crystal, for putting together a brilliant and much needed conference on law, land, and justice. Land and justice has long been central to Native communities, Native nations within North America. And I think no one has really framed the issue better than our practitioner scholar, Leanne Simpson, an Anishinaabe scholar, First Nations, who sees land and its relations not as simply a space for justice in the way that the nation state forms it, but as a way to learn. Land is pedagogy, land is practice, land is relations, land is a space to be able to reformulate and reshape the good life for communities of all kinds, even and especially communities of color, Indigenous communities, and majority minority communities. And so this subject has been close to my heart and my community and my scholarship for a very long time. And I've learned extensively from our practitioners within Indian country, but I'm excited to learn how these ideas and concepts of land and justice have played out across contexts beyond Indian country as well as within it. And I'm especially interested in to explore the ways that law may have a role
either in inhibiting these processes or moving them forward. And to that end, we have a wonderful panel who has been introduced, but we will begin with Akilah Brown. And I have questions for each panelist, and we'll hear from each, and then we'll open it up to questions from the audience, as well as a discussion among us if we so choose. So Akilah Brown, since 2017, the New York City Community Land Initiative, so the initiative, has employed tactics to advance community control of land and housing. How did the initiative come about? And help us understand land use in New York City today and the need for alternatives and the potential of community land trusts.
Got you. Thanks, Professor Blackhawk. And I just want to echo the thanks to Crystal and all the editors and organizers of this event. I was only in law school only a couple years ago, and I couldn't have imagined this topic happening. And the fact that it's been done with such clarity and such vision, it's inspiring. The keynote was more than inspiring. So just thank you all for making this happen and creating this space. As you noted, I'm here on behalf of the New York City Community Land Initiative, which we endearingly refer to as nicely NYCCLI. And we're a coalition of community land trusts, which I'll refer to as CLTs, community-based organizations and CLT advocates, all working to advance CLTs in New York City, but for three main reasons. First, that's curbing speculation and displacement. Second, that's creating permanently affordable housing. And third, that's ensuring community decision-making and community leadership over neighborhood development. With that said, I'll note that the work and the foundation of NICELY started way before 2017. And I'm frankly a baby practitioner in this space. I'm sitting on the shoulders of honestly powerful and inspiring activists who have been entrenched in this work and who've secured powerful victories for the movement in a short period of time. It's a movement that grew out of the deep organizing of a member-led group called Picture the Homeless. They were focused on addressing the root causes of homelessness and housing insecurity. At that time, they were fighting against the criminalization and marginalization of people experiencing homelessness, but they were also refusing to accept the fact that homelessness and New York City had to go hand in hand, which I guess with this audience, it may not even need to be said, but when a major industry of New York City and a driver of Wall Street is real estate, that assumption I think is so easy to accept, right? So those members were exploring the different factors that led to the precarious conditions in their neighborhoods. These were Black neighborhoods, brown neighborhoods, low income and immigrant neighborhoods. The conditions that they were exploring relate to your question about what's happening in New York City and why we need alternatives. So we know, and I know NYU is connected to the Furman Center, so there's been lots of studies on this, but there's a housing and land use crisis in New York City and throughout the country. About half of the city's households spend more than 30% of their income on rent, which is defined as rent burden, and rents continue to climb at a pace completely out of step with the wages, especially for low-income tenants who still have to fight for a livable wage. The city's strongest guarantee of permanently and deeply affordable housing, which is NYCHA public housing, has a huge shortfall of almost $40 billion needed for crucial capital repairs. Many tenants find themselves trying to figure out which battle they're going to fight on any given day. Poor housing conditions, harassment, and even worse, eviction, which we're coming to head with now. The city also puts a disproportionate amount of money into temporary shelters instead of deeply investing in long-term affordable housing. And in the last few decades in New York City, we've seen an increase in upzonings with almost no regard to and protections against the resulting adverse racial impacts, namely displacement of Black and brown residents, those small businesses, not to mention the over-policing of Black and brown bodies once the police are trying to protect these now gentrifying white and affluent spaces. I can go on and on about the depths of our crisis, but all those things, I think it's important for us to remember that all those things are circumstances. They're products, byproducts of our housing and land use crisis. They're not the cause. So to take it back to Picture the Homeless, their members who were also involved in deep political education, they recognize that one of the major causes of housing and neighborhood destabilization was the commodification of real property, right? Land and housing are treated as commodities, bought and sold to the highest bidder with profit as the main goal. Housing is rarely treated as a human right, and that leads to the massive amount of speculation and value extraction that we see, but particularly at the expense of Black and brown communities, right? We saw that chart, that timeline that Professor Atwahane had about just like the road from redlining to urban renewal and so forth, that just shows you how housing is not treated as a human right, but who has been affected are Black and brown communities. A second root cause that they recognize, which actually stems for the first, is the fact that those who make the decisions about housing and community development, whether they're private developers or frankly city agencies, are almost never the people who live there. So with that understanding, the CLT structure, the community land trust structure, was brought to the table as a promising tool to begin to address those root causes. I believe you're going to get a lot of detail about how CLTs work in practice. There's a few land trust folks here on the panel. But I thought it would be helpful if I provided the general framework so that we're all starting from the same grounding level. So CLTs are broadly defined as nonprofit organizations that treat land as a public good. When a CLT is able to obtain land, it's taking land and properties out of the private market so the community can then steward that land in ways that benefit the community in perpetuity, right? So at its root, the CLT is a model of shared ownership and a model of community ownership. The shared ownership comes in through somewhat of a bifurcated structure. The CLT owns the land, while owners or renters or farmers or community artists can own or rent the property on top of the land. Those two parties then are connected through a 99-year renewable ground lease that usually includes things like resale or affordability restrictions, but it really ensures the permanence of community benefit and that agreement between the CLT landowners and those who occupy the structures on top. Another key component is that a CLT is community controlled, and that's key, right? The community control is a function of the board that oversees the CLT, which typically includes a portion of CLT residents, a portion of community stakeholders, and a portion of expert stakeholders. That mixture is intended to balance resident interests with broader community interests. And that means maintaining accountability to the community needs and the CLT principles over the long term. So that's just like a quick overview of the CLT, but with all that in mind, you can likely see how it was a promising tool for folks who were organizing against homelessness as a condition of housing commodification. These were organizers who, with the support of activist planners and researchers, found that there was enough vacant property in 24 of New York City's community districts to house almost 200,000 people. That was nearly 4 times the population of the city shelter system at that time. So essentially what they learned was that the property was there, the tools to bring land into shared community ownership existed, but the political will was absent. So the question became then, how can we create the structures and push for the policies that take land off the speculative market and into the hands of communities to address their deepest and most fundamental needs? I'm talking about housing and affordability. I'm talking about environmental degradation, disparate health effects, comprehensive education, holistic recreation. There's so many community needs that go unmet, where land and collective ownership of that land can be the tool to address that. I think one of the questions earlier asked, like, have you seen situations where properties come into collective ownership? Because the community land trust is a perfect example of that. And then once we get that land, how are we ensuring that land is maintained and accountable to those needs for the long term, for generations to come, not just for one generation? In many ways, a CLC, if properly stewarded, enables that. And it really challenges us to think about ownership, not in the context of individual ownership, which, as we heard, only goes so far in building the kind of comprehensive wealth that long neglected neighborhoods, Black, brown, and immigrant neighborhoods so desperately need. But the CLT challenges us to think about ownership in terms of the collective. So, for example, while there may be limited equity housing on a CLT, which means you can't make a full profit from living on the CLT if it's home ownership, that allows families to start building a little bit of wealth, but that ownership opportunity is elongated and expanded to the rest of the community through a CLT. The ground lease that I mentioned earlier keeps that property affordable and gives the next family who moves in an opportunity to obtain limited equity, or frankly, even just an opportunity to have a stable roof over their head. Also, that family has an opportunity to exercise agency in a system that tries so hard to diminish that for Black and brown folks. They have the opportunity to say what, where, and how properties are being stewarded through the CLT, which is foundational to building community wealth. So since that history, and actually during that time, there were only a couple of CLTs in New York City, notably Cooper Square CLT on the Lower East Side. But since then, more than 15 groups across the city's 5 boroughs have been organizing to create CLTs, have established CLTs, really using the flexibility of the structure to achieve community self-determination and affordable housing in our Black and Brown neighborhoods. Michael Johnson is going to speak about the work of the Mott Haven Port Morris Community Land Stewards, so that should be good. So I'm going to actually stop right there because I know I'm over time, and we have organizers on this panel to talk about that work. But again, thank you. I'm looking forward to it.
Thank you so much. And it's a wonderful transition into my question for Michael Johnson. And that was, can the initiative's efforts be understood as a continuation of New York City's rich tradition of environmental justice activism, which also centers local autonomy and land use decision-making? And what environmental challenges does your Bronx community face, and how have you resisted them?
First of all, I want to say thank you, Maggie, for and all of you all from the New York University Law Journal, Environmental Law Journal. It's really important. I'm glad I'm having the opportunity here to talk about some of the environmental issues that face the South Bronx. I'm a founding member of South Bronx Unite. I live in Mott Haven in Port Morris, which is the southernmost tip of the South Bronx, the South Bronx, deep South Bronx. So I'm sure you all, and most of everyone here has heard the negative connotations of the South Bronx and some of the environmental harms that have been placed upon us by the built environment, right? By being a place where we handle, some of the largest concentration of industrial development in the city, with heavy diesel truck intensive businesses roaming through our communities, surrounding us with highways, having fossil power plants, pushing smog and other carcinogens into our air, creating a situation where 1 in 4 of our children have asthma. We as parents, as a community, stood up to fight back against the injustice that have been done for decades here. The environmental challenges have been placed upon us because of top-down decision-making. And it's all been rooted in how the land has been used. So it's really unique to have this conversation about free the land, because that's exactly what we've been trying to do. We were born, South Bronx Unite, out of the environmental justice advocacy need for to make sure our community has the right to breathe, but also a right to stay. And we've seen how public land has been used as like the nucleus of all the assaults. I mean, Robert Moses, created the Cross Bronx Expressway, carving, trenches through a neighborhood, and they didn't stop there. From one governor to the next, after that atrocious use of land, they continued the highway systems and surrounds. They continue to dump on this community. And so what we have been looking at is how we can really utilize public land for the public good, how we can make sure that the environmental justice needs we have here, because of the environmental injustice we've been plagued with, we can create different opportunities. How we can reverse this cycle of disinvestment and make a holistic approach to creating quality of life enhancement. So where we see public land has been used for dumping, for waste transfer stations and heavy diesel truck intensive businesses, we want to put green space. We want to make sure it's owned and operated by the community. So our fight for environmental justice led us to creating a community land trust, like Akila mentioned, but with a focus on capturing public land for the first purposes of creating healthier outcomes, creating permeable surfaces along our peninsula, which is a flood zone, giving access to 60,000 people who have no access to the peninsula which surrounds them. The injustice has been plagued here for over and over again. And even in light of recent, we've seen how public land is being used to put a prison in our neighborhood when we already have 3 prisons in our community. So when does it stop? Why do we continuously have these situations where you have a school to prison pipeline, you have all the industrial sightings in this one neighborhood, you have no investment for infrastructure, our schools are the poorest performing school district in the city, and all this is around environmental injustice, all around the land that has been used to cause all this harm. And so our insight was that let's make sure we can create the solutions and not just look at the problem. So we're about creating solutions, and we feel the solution is really making sure the land, we make sure we create our own, we create the own situation where we are the guardians of our own public trust, and making sure the public land that still exists will provide public benefits for us, and not what we're expecting to come from the top down, because it never does. So we initiated our community land trust to make sure we can create the destiny forward for our children and our children's children. When we go to our local schools and have a conversation about environmental justice, it's not about hugging trees, it's about the ability to breathe. It's the ability to go to the waterfront and experience water like any other community does, not necessarily having to get into it, but be close to it. So we want the natural resources that are required for healthier outcomes. And that's what got us here. And I'm happy to be here today to talk a little bit more about that.
Thank you so much, Michael. I'm going to turn next to Satish Nori. So your advocacy makes a novel connection between the housing and unaffordability that Akila describes and the environmental degradation that Michael describes. If you could please provide an overview of Hurricane Ida's impact on New York's low-income immigrant communities and let us learn a little bit more about that process.
Thank you so much, Professor, and it's a pleasure to be here. And I too would like to thank Crystal, who I had the pleasure of teaching at the law school. So let's get into it. In September 2021, 43 people died in the aftermath of Hurricane Ida in the greater New York area. In New York City, 13 people died in basement apartments, including a 2-year-old boy named Ang and his parents, who drowned as unexpected floodwaters rushed into their basement home. Ang, Mingma Sherpa, and Lobsang Lama had recently immigrated from Nepal to seek a new life in Woodside, Queens. Their dreams died with them because they were victims of two colliding forces: climate change and the affordable housing crisis. News reports were quick to identify the villains in these basement deaths: greedy landlords, reporting that the NYPD was exploring criminal charges against them. But basement apartments represent more than the traditional struggle between landlords and tenants, battles over rent, repairs, and space. The prevalence of basement apartments as a housing of last resort means that our housing policies have failed, that they have unfairly pitted low-income communities of color against one another, and that if we don't address this issue, climate change will further displace, bankrupt, and even kill people in these communities. Basement apartments are the outgrowth of systemic underinvestment in communities of color. In White Space, Black Hood, Professor Cheryl Cashin describes the government's overinvestment in white neighborhoods and disinvestment in others. This disinvestment went deep, affecting roads, transportation, and housing infrastructure. When people from communities of color, lured by the American dream of home ownership, went into it head first, they often got much less than they bargained for in terms of location, quality, and value. It's likely that this underinvestment in infrastructure negatively impacted roads, sewers, drains, and other flood protection measures. The issue of illegal basements pits middle-class people of color as landlords against low-income people of color as tenants. The alluring undercard fight, distracting us from the real issue, the lack of safe, decent, and affordable housing and investment in communities, low-income communities of color. Meanwhile, the climate crisis, like a ticking time bomb, makes any workable solution to unsafe basements fleeting, like sand in the floodwaters. Basement apartments represent a failure in our housing policy. Basement apartments are rented out because the goal of stable home ownership remains out of reach for many middle-class homeowners, many of whom are Black or brown. That too many tenants rent basement apartments means that we lack an adequate supply of safe, decent, and affordable homes. We can tinker on the fringes of this problem with policies to make basements safer in the short term. However, eventually and inevitably, climate change will force a reckoning with our failed housing policies. These failures will impact the most vulnerable people in our cities, Black and brown tenants, immigrant landlords, and communities of color.
Thank you so much for that moving description. I'm going to turn next now to Leo Figueroa Helland. So let's turn our attention from the local environmental crisis that Satish described to the global climate crisis. Your scholarship examines settler colonialism and its after effects during the Anthropocene, our current ecological era. So what is land rematriation, and why does land rematriation hold promise for ameliorating the climate crisis?
Vanessa, everybody, morning. It's an honor and a pleasure to be here with you. I want to also thank the organizers. Thanks, Dr. Blackhawk. Thanks, Crystal, for putting this together. And it's really an honor to be here with you. So yes, I'm going to take us a little bit further into the global field and the relevance of land rematriation to addressing climate crisis and biodiversity crisis. So rematriation, according to Steve Newcomb, the Lenape-Shawnee scholar, means to restore a people to their rightful place in their sacred relationship with their ancestral land base. Now, I want to start by acknowledging that I speak to you from the unceded lands of the Lenape people who have been displaced through deceit and fraud that now live dispersed throughout Turtle Island in places like Oklahoma, Wisconsin, Ontario, and in 2 reservations in New Jersey. Now, Lenape people, like people of the Northeast, native people of the Northeast, were known to manage landscapes, to tend to landscapes in a way that enhanced the biodiversity and carbon capturing capacity of the landscape. But that was not the primary reason for their landscape management practices, but instead it was to nurture vast forest garden systems of useful species to both humans and non-humans. In fact, the Northeast forests, as we know them today, are an inheritance of the deliberate creation of indigenous natural gardening practices. Like in the Northeast and many other places of the world, indigenous peoples have been deliberate keystone cultures in enhancing the biodiversity of ecosystems over thousands of years. The Amazonian peoples, the Mesoamerican peoples, the Southeast Asian peoples like the Dayak peoples, Adivasi peoples, Chaga people in Tanzania, the Baka, the people of the Congo River Basin, everywhere you look at, you see thousands of years of deliberate interaction of reciprocal care for nature in fostering vast, rich ecosystems in which humans cannot own them as property, but instead we have a responsibility to enhance their richness and vitality. Now, this is fundamentally contrary to any cosmovision or ontology of property. The concept of property that's brought down from the principle of Eurocentric philosophical and legal thought is rooted in the principle of human dominion over nature. In native cosmovisions and indigenous cosmovisions, it is the land that is sovereign, and it is us who must organize our way of life in relationship to the rules of the land. Here in Turtle Island, it was the doctrine of discovery that was invoked to dispossess indigenous peoples of their lands, which is the foundation of the so-called sovereignty of the settler state, illegitimate in all of its terms, and to this day still cited as the basis of the US sovereignty. For example, the doctrine of discovery has been cited by the US Supreme Court as recently as 2005 in City of Sherrill versus Oneida Nation of New York. Writing for the majority, Ruth Bader Ginsburg stated that, and I quote, "Under the doctrine of discovery, fee title or ownership to the lands occupied by Indians when the colonists arrived became vested in the sovereign, which is of course the United States, first the discovering European nation, and later the original states of the United States. To this day, the doctrine of discovery continues to be invoked as the principle of organizing social life." Now, in the Northeast, there are multiple struggles to rematriate land and to center indigenous perspectives of land as sovereign. It is important to point out that our partners at the Northeast Farmers of Color, who are represented here by Saka Ivaire, have been doing a lot of work to reconceptualize notions of land as sovereignty through rematriation. Land rematriation is not simply land access. It does not mean land access within the terms of the dominant property regime. It does not mean public property. It does not mean private property. It doesn't also mean only the recognition by states of customary ownership by indigenous peoples. It means the reconceptualization of the geographies of land in terms of the cosmovisions of indigenous peoples. and the weaving of those cosmovisions with the cosmovisions of dispossessed peoples and diasporas who have been here as a result of imperialism and continued land grabbing. So as we move into the concept of rematriation, it is important to be very aware of the many ways in which the value of indigenous peoples' knowledges to address the climate crisis cannot be used as an excuse to incorporate indigenous peoples' lands into so-called solutions such as carbon offsetting. Oftentimes you have large NGOs such as the Nature Conservancy or the World Bank, an intergovernmental organization, arguing that indigenous peoples' lands must be titled not primarily within indigenous peoples' cosmovisions, but as a way to incorporate indigenous peoples' land into a green economy of carbon offsetting and compensation. This is problematic in that it doesn't mean decolonization. It doesn't mean dismantling settler or state or capitalist concepts of property. It means seeking to reinscribe them by incorporating indigenous peoples' land tending practices into a green economy of nature that allows polluters and land destroyers to continue extracting elsewhere. So we must differentiate mere land access from land rematriation and decolonization. I will stop there and I will give it back to our moderator, Maggie. Thanks.
Thank you so much, Leo. And you've referenced already our next panelist, Saka Yaver. And so let's turn to his conversation next and his work with the Northeast Farmers of Color Land Trust. So the Land Trust has partnered with the Earth Law Center to devise legal tools that promote kinship with the land. Could you tell us a bit about that work and what is your organization's vision for land tenure?
Thank you. Gratitude to the organizers, gratitude to you, Dr. Blackhawk, gratitude to all of you listening and the panelists. I'm looking forward to what sort of conversations we might have moving forward. This is my first time seeing some of you and I've heard much about you. Ito everyone, ahiki saka, ki the work of Northeast Farmers of Color Land Trust is tied to a desire to unravel the confines of the human versus non-human binary that's present in law. We know of the history, we know of the trauma, we know of the practices that are imperialistic in origin that seem to continue to devastate and present obstacles when it comes to collective well-being and kin-making. We are a land trust who currently does not possess land. And I make the statement quite regularly that what we are doing is we are building trust. And that needs to be established prior to really engaging the difficult and challenging conversations of land tenure, as far as I'm concerned. Our partnership with Earth Law Center, I should continue with this. As a land trust, we are building upon two models, the community land trust model and the conservation land trust model. So we are both and neither, in the sense that we are not interested in land possession. We consider ourselves to be something of a black box, as you might say in design, through which land that is part of the ownership or a private property regime enters into our space where we are making and working, and we develop tools that allow it to leave that space as something else, something beyond, something away from these private property. Our partnership with Earth Law Center is a very exciting one, and it is tied to two projects in particular: the development of an ecosystem stewarded land trust. Others might say an ecosystem owned land trust, and the development of a border to border from the US-Mexico border to the US-Canada border corridor for allowing for all species migration. We're pooling lessons from India, Peru, Sweden, and Canada And with a critical mind, we're committed to setting up all the roadblocks that we can in relation to, again, the human versus non-human binary. We're using models that are related to animal property rights, agroecology, indigenous just transition frameworks, and spheres of transformation. That these things are helping us think about what an ecosystem-owned land trust might look like and how we transition from a concept of ownership to one of kin-making, in which we continue to recognize our relations and act from that wisdom that has been present and continues to be present. Does that answer your question?
Very much so. Thank you so much. Yes, no, so this is amazing to see the intersections between the approaches and the fights, the struggles across both urban and rural landscapes. And I'm fascinated to learn more about the tools that seem to be similarly used across these contexts. I was struck by the reference over and over again of the limitations of law in each of your presentations. So we have the limitations of the law of property, which we all know was developed in the context of American colonialism on the North American continent. We have and the housing policies that have then arisen from that vision of private property that was developed to exclude and to dispossess, as well as the lack of environmental regulation and the discriminatory policies that do seem to over and over again entrench power and capital within a particular subset and demographic of our political community, despite very formal references to equality and to redistribution. So the limitations of law were just on its face very prevalent in your presentations. And my students often come to me who care about these issues frustrated because we are lawyers. We are paying money to be trained in the law. I train lawyers for a living. And so to approach the issues that we care about most deeply with tools that seem inadequate or even subordinating is hard. However, I was struck by the similar use of the law, creative use of the law to be able to combat some of these issues, and in particular, the tool of the community land trust. Community ownership as a means, leveraging private law to try and restructure the political ecosystem, the environmental ecosystem, and the day-to-day lives for communities that have been subordinated in the United States for a very long time. And I was struck similarly about the similarities between the trust relationship and the taking land into trust that exists within Indian country. So Native nations have land taken into trust across North America and own land collectively across North America in reserved lands. And so this kind of sub-constitutional structure of creating a community land trust is something that Native people have been engaged in for the last 200 years as a means to combat and find a space for self-governance, for dignity, for those basic human resources that Michael described, and to be able to control at least this small subset of our world to find a place of justice and of the common good for our children and generations to come. And I was just struck by the similarities between those two legal structures. And so I was hopeful if anyone would like to speak more about their own experience with these community land trusts. Any thoughts about the similarities and dissimilarities across these forms of collective land ownership? Oh, please go ahead, Michael.
Yeah, Maggie, I just want to circle back a bit. And I think it's important that we get out of the whole commodification of land conversation more to our need to steward this land. We don't own it. We had to get out of the commodity. We have to get out of that mindset. Our community land trust is called the Mount Haven Port Morris Community Land Stewards because we know we don't want to reproduce what's been happening to us over and over again. It's about taking it off the speculative market. It's about creating a way forward where we can thrive and live, because we have been put into place without our fault, because of decisions that have been made for us and not where we're making them for ourselves. So I think we don't want to reproduce that of our slaveholders. We don't want to reproduce those of our oppressors. We want to create a situation where we understand from top that we don't own it. We only want to steward as long as we're here. We want to make sure it's for the people. It is not for commodification. It's not for necessarily for the tallest skyscraper or that's why we didn't focus initially on housing. We have not focused on housing. Not that it's a problem. That's not that we don't have housing issues. We do, but we also have other issues, that social societal issues that need to be solved. And I think the only solutions come from us. And stewarding, I think, is the way we felt is the most sustainable and without commodification as a part in the play and playing into that.
That's fascinating, and an important point to think about how community land trusts through this private property system force a property framework, force a vision of ownership in the context of community land trusts. Within the context of Native nations and reservation lands, those lands are not owned. You could call them collective ownership, but they're not leverageable or mortgageable or commodifiable by Native people. And ridiculously and sadly, it's that doctrine of discovery that Leo referenced that's preventing that, but it also allows a space of a different relationship to land across generations, even if traditional relationships to land are lost. The legal system doesn't force that on Native people. And so I wonder if there is a way. It seems like, at least theoretically and intellectually, we are trying to move and reshape this private property system into something that's closer to our Native Indian law system of collective belonging, of reserved lands in which nation states exert sovereignty, which Native nations do. But I wonder if there are further similarities and ways in which we could take this private property system and move it more closely to that which Native nations already enjoy.
So I'm just going to quickly maybe complicate this conversation a bit more, and it's probably not where you wanted to take it, Professor Blackhawk, but I think what Michael said about staying away from housing is so key to the challenges that I think arise, at least in trying to form housing focused community land trust in New York City, right? Or even trying to deal with any New York City agencies that have any ties to certain land, right? This isn't, now there's lands on the market, there's properties on the market that transfer hand to hand, person to person. And you actually have a little bit more flexibility with that if you don't need outside financing, if you can just get it off the bat, right? But what happens when you need to get loans or work with certain funders or lenders or work with certain city agencies? Then you have to start to try to explain these theoretical concepts to them. And you have to start to get them to understand why like every single term on their term sheet is rooted in that idea of commodification and private ownership, and doesn't even begin to understand what collective ownership and collective governance looks like. And that is an uphill battle. And I'm not the one who's entrenched in this work, so I can't speak to that day to day, but I've heard it from nicely members, right? Why it's like they're constantly trying to say, HPD, first of all, HPD is our city's housing agency. Give us more time so that the residents coming into this space understand these terms, right? Or let's think more strategically about how you're leveraging this property or giving us funding for this property because it actually doesn't match what we're trying to do. And that, I think, is a challenge when you speak about trying to form a CLT in an urban area like New York City, where they're so used to business as usual. And I think what you're saying is interesting to me. It's like, I kind of wish we could be in more spaces where that battle of language has already been won, and that battle of understanding has already been won, so that we're all starting from the same point, but we're not. And actually, some of my work in my previous fellowship was trying to help be that liaison between agencies and CLT groups, so that they're in a constant, so that we're constantly trying to kind of almost like politicizing and educating our agencies so that they just understand how this structure work. So I'm just going to add that additional complication in when thinking about the comparisons of community land trusts.
It's a great point, and it's a fascinating one, because I think I wouldn't go so far as to say within Indian law and conversations between Native nations and the collective holdings of land that's in trust has been resolved in these broader conversations with state, local governments, with markets, leveraging for mortgages, especially with respect to housing in Indian country, is still very difficult, but the conversations are strangely the same. And they did start a bit longer ago. There is an interesting space about rural versus urban, but even in, this has been complicated. Not all reservations are in rural communities. So there may be a fascinating space for conversation there, where these conversations have been started, and we do have specific government structures to translate it. So you don't have your own nonprofit having to do all the work, that there are separate agencies that are trying to work as translators between all these areas and to pass laws and structure and regulate these conversations in different ways, but through compacting and other forms of agreement. But fascinating space. So any other thoughts on the CLTs and the use of law creatively to solve these problems? Leo.
Well, if I may kindly jump in, I want us to further complicate the conversation, if we may, appealing to what Michael and Akila were saying. In sort of connecting with the international indigenous movement, including its representatives from Turtle Island, within the context of the climate crisis, the mass extinction crisis, the tremendous destabilization of the Earth system as we see it today. I think there is a pretty agreed upon consensus that the ontology of dominion upon which the property system is rooted, including private property, public property, state property, is coming to a certain limit, historical limit to its reproduction at this stage, an environmental limit. We are kind of reaching the environmental limits of the viability. And, indigenous knowledge keepers, elders from across the world have always seen engagement with the property system as strategic, as sort of a strategic engagement with a system we do not choose to live in, but we must learn to accommodate and creatively recreate, right? But I think we're also coming to a historical endpoint to that sort of double world, right? In which it's clearly visible that we cannot continue with this sort of ontology and the legal apparatus that is built on it, because of the environmental consequences that it has created, that it is time for us to kind of put forward the cosmovision of the peoples. It's time for us to more assertively confront the desacralization and commodification of nature, and to reconfigure it, to challenge the geography of settler states, the market system, and the like. So while, in the meantime, we continue to negotiate within the shells that have been imposed on us, we nonetheless need to have a vision of a future that's not distant anymore, like climate catastrophe, hothouse Earth, planetary boundaries, tipping points. This is not a tomorrow, it's a today. It's a today in which we need to right now reimagine forms of land tending, forms of consensus, collective land care that are well outside of the system of property. So, I would just put that out there.
Thank you so much. So we have quite a few audience questions that are building up, and I'd like to turn to them now. So the first question is specifically for Akila, but of course others are free to chime in. This is a broader discussion, so please feel free to bring your thoughts to all these questions, but it's specifically for Akila. So we have an audience member who's interested in hearing your thoughts on encouraging Black and Brown people to move from cities like New York to more affordable cities like Detroit.
I think I answered that question. I'll read my answer out loud. I was trying to get to them while I was in the chat, but I answered that I think it's up to those households. Like I can't say whether people should be moving here to there, but I think it's key that if Black and Brown communities have a right to stay, right? Like if that's what they choose, and if they're committed to those community ties, and many are, right? Like people don't want to be displaced. Then it's our job to then be creating the conditions and the spaces so that if they want to stay, they have that right. It shouldn't just be that development and unaffordability just means that they have to leave. So the idea is, how are you recreating the systems, transforming the system so that right exists?
Thank you so much. So our next question turns to that, how do we operate within the shell of the legal systems that we are in? And specifically a question about the community land trust governance. And so how accountable are CLT board members to the wider community of membership, especially in a tripartite structure? Can they be recalled quickly, or do they operate similarly to elected representatives for a set period of time?
I can start, and maybe others can chime in, but I think that it all depends on how carefully you draw up those bylaws, just from a legal perspective and from an organizing perspective. I've seen some really radical and transformational bylaws, specifically actually on the West Coast. I forget which cooperative it was. Once I remember, I'll put it in the chat, but they've drawn up some really accessible and thoughtful bylaws that allow for a mix of interests. You need to ensure that resident interests are being maintained, but the interests of wider community members are also being maintained. And there's a strong accountability structure in that. So it comes to drafting the bylaws. Once I remember the organization who's done a really good job at that, I'll share it in the chat.
I wanted to add to that. I think the bylaws are critical. You know, our Northeast Farmers of Color Land Trust was established by a network of alienated farmers of color. And when they secured resources and leadership and personnel in order to work on building this trust effectively, what was established was a sort of interim council that had been voted upon by the membership of the network. And then there was a move to establishing a formal board, which was also very elections based. And now there's the work with our Indigenous Territory Protocol. There's the work to develop circles of accountability, circles of counsel that present a fuller spectrum of community voices when it comes to decision making or stewardship of what is this trust. I think that in addition to bylaws, though, and this is perhaps speaking again to Akila's point about the uphill battle of the work to communicate what it is that one is doing, the partners with which you begin to establish, the partners that you establish relationships with, that you begin to continue working, really influence the governance as well. Those partnerships are key. They are not only key, but they are platonic in the sense that they tend to be explosive in certain contexts if they're not handled or managed well. So relationships are a big part of the governance, clearly.
I just want to add one thing. I do agree as well as the bylaws. It took us almost 3 years to actually form it and really finish ours. It was so important because we, again, want to ensure just that we're representative of the community. But ultimately, the most important emphasis or part of a community land trust or a community land stewards is community. It's organizing, 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 and it don't stop. You can never do a good enough job, right? You can never become like you've reached everyone. You have to continue. This is an effort that's continuous, and it has to be continuous to be successful, to be responsive and representative of a catchment area. And it has to be a defined catchment area. It can't be an endless border of a community land trust, because then it's not a community. And so I think it's key, and that's how you make sure and ensure that you are responding to the community itself. And if you're not, then you should be replaced, or the community land trust is not serving its mission, which it's all about the community. It's not about individual entity. Else you can be a trust, or you can be a land trust. But if you put community in there, it has to be emphasized and community, and it has to be focused on that catchment area of people who live there and their unique needs.
So I have a question that has come from our students for you all as practitioners. So what work experience would you recommend that law students who want to be involved in this sphere seek out?
I was going to let Satish or somebody answer, but I don't know if you caught the question.
Could you repeat the question? Somebody just popped into my office at the—
Oh, no problem. It really is a question I get from students quite a bit of how do they, what sort of work experience, how do they plan their careers to do this sort of work? It's not a clear trajectory. It's an area of creativity in all sorts of ways, and it's really path-breaking work. So how do they possibly hit that path-breaking work and plan for it now as law students?
Yeah, it's a great question. I think in any academic or graduate type setting, there are kind of existing roads. And this is true in many walks of life, where you're just kind of following someone else who maybe walked the same path before you. And so for law students, especially, there's only like 3 or 4 real paths that people seem to find themselves in. So what I often say to law students is essentialize the things that led you to law school. Like, think about the principles and the ideals, things like being for a human right to a home, or to a human right to whatever principle you believe in, things like free speech or reproductive rights, or whatever it might be, and then work from there and say, now where can I make an impact? Where can I learn the most? Where can I be creative? And I think that's a much better way to go than to just follow the beaten paths that exist in places like law schools, particularly law schools like NYU. So if that helps, that's what I would say is, attending panels like this are great ways to expand your horizons and to understand what issues exist and what areas are unexplored. I was particularly inspired by the plenary talk this morning, and I learned so many things about the concept of dignity restoration. I particularly responded to Professor Atoheni's answer about what do you do when different communities are pitted against each other over the same land, and kind of the timeline approach that she took on. And I found that to be really inspiring. Like, where do we start? Do we scrap the whole system? Do we start at a particular point in time and work forward? How do we weigh the interests of different communities who've had an attachment, a connection, an ownership, a deep connection to the land? So this is a great start. It's a good thing that you're here if you're asking that question. Just be creative and be open-minded about what you might end up doing with your career, with your training, with your intellect.
Thank you so much. I know I get that question a lot, so it's a wonderful answer to have on my fingertips now. So the next question we have is a little bit more big picture theoretical. So if we view real property not as private ownership, as it is through our current property legal system, but as a community good, as many have mentioned, as Michael mentioned, stewardship, and how do we, that is based upon use, how do we decide the use of real property? its distribution, and deal successfully with the quote tragedy of the commons issue.
I'll take a shot at that. What we've done to determine potential uses of spaces, talking to our community, envisioning sessions, getting our community together to say, hey, here are some assets. What's best needed? What can we use this space for? Not solving all of our problems, but trying to attack some of those problems. Like was mentioned about the terminology used by Bernadette that Satish just mentioned. Say that again, Satish, because that's something I want to write down, man. It's powerful. Come on, take yourself off mute for a second. That was about
Which part did you refer to? I'm sorry.
About restoration.
Yeah, it was about the finding a point in time and moving forward and saying like, how do we make amends? How do we restore some dignity?
And that's how we do it.
Yeah.
Bring a community together to restore, and finding out, not having to engage the community is the way what we want. That's why we've had situations unfold. There's not been engagement. So we're engaging and envisioning together to figure out what uses are for these spaces in these places to create different outcomes. The waterfront plan, we've now have prioritized as a space that we could reclaim and restore. That was documented to be a Native American burial ground and settlement. We want that back to be owned by the community. It's a publicly owned space by the state of New York, but not being used for the public's good. We have public property that are vacant that was used to create public good. We are reclaiming those spaces to restore ourselves to healthier outcomes. But we only can do that by letting our communities envision what those spaces should be. With the understanding we're not going to solve all the problems only in these spaces, but it has to happen organically and collectively. Thank you, Satish.
Akila?
Professor Atwahane also explained the importance of process, right? And I think that for me particularly resonated. It's not so much thinking about the end goal, but what is the process that's bringing everyone into the space? And I use everyone very carefully because it also means starting from the understanding that we are all on stolen land. For a long time, Black bodies were property, right? And then for even longer, Black and brown neighborhoods have experienced plight after plight after plight. Again, I'm referring to that timeline that was on the slides, right? And so you have to start from there. You have to say, it's not just enough to put out flyers and give everyone this space. It's about actually lifting up Black voices, brown voices, low-income voices, making those the most powerful voices in the room. Even though I think that sometimes works against people's idea of equality, but that's not what we're shooting for, right? We're shooting to be in right relation with our land and with each other, given the hypocrisies and contradictions of our unequal system previously. And so that's about process. And then whatever outcomes come from that process determine the way forward, but you have to create that process carefully and with a racial justice lens, specifically when it comes to land justice.
Yeah, thank you so much. And I think, there is if you don't mind me answering a little bit from the Indigenous context, we have lessons from this for the last 200 years of United States governance, of how we deal with enclave nation states approaching property differently within their jurisdictions and dealing with problems of the public good. And as Michael and Akila have described, it's not no governance, it's different governance. It is not a free-for-all anarchy when you don't have this vision of exclusionary private property. It's a different relationship to land. And it's a different political economy where folks who live on that land, who are stewards for that land, make decisions about that land. And you can see over the last 200 years of United States history how our federalism has turned from a distributed vision of local control and sovereignty and people being able to make decisions for themselves, entrenching more and more into pulling power from local communities, pulling power from those communities that are further and further segregated from one another, and then disempowering them by taking the ability to govern away from them. Through capital distribution, through the taking of restructuring of government to have decision-making located elsewhere, the national government, the state government, away from whomever will wield majority-minority governance. And so much of this process isn't about anarchy of destroying visions of governance entirely. It is rethinking that and rethinking those legal systems through that different vision of governance. So that vision of process that Akila described, that idea of bringing the community in, of raising up those Black and brown voices, those are the people who live there. And so they are the ones who are most affected by the regulation of that space. And so they should have the greatest decision-making. So even in our world of formal equality, if the regulation only affects one person, that person should really have more of a decision-making in that process. And so we should recognize that in the political economy of how we govern property, even if that means not abolishing the property system entirely. I did have a quick follow. Oh, please, Leo.
Yeah, thanks, Professor Blackhawk. I would like to kind of follow up on that. I think there is a serious necessity for us to think thoroughly through the history, not just of dispossession of land, but of the deliberate dismantling of traditional governance systems, communal governance systems. And we need a kind of a very deliberate effort to reconstitute some of those traditional governance systems. Because the process of consolidation of the property system is primarily guided by the association with property with economic growth, right? The dismantling of indigenous governance systems, their incorporation into property regimes that would facilitate their participation in productive activities, their participation in the market system, right? That sort of rationale for the property system has to be shifted over to a rationale where property gives way to the commons, that we reconceptualize the ways in which we govern according to communal land tending for the purpose of the restoration of the commons. And here again, I mean, I hate to bring back the long view of history in the sense that, you know, just like traditional governance systems of indigenous nations, Central Island, as anywhere throughout the world, were rapidly dismantled through processes of assimilation and incorporation. We are at a stage in history where many of the environmental consequences of the property regime are rapidly unraveling the capacity of state and market systems to manage the consequences of economic growth. So restoration of the commons is fundamental, but it cannot be done without a clear re-examination of how do we reconstitute traditional governance systems, communal relations to land.
Thank you so much. I have a follow-up question from a student on the practitioner question of how to get into this line of work. So for practicing lawyers in the general human rights, social justice sphere who are interested in incorporating land justice specifically into their work, do you all have suggestions on avenues for incorporating this into pro bono practice or other means of both learning and getting more deeply involved?
I might have a cynical response to this. Before I went to law school and throughout law school, I was managing a pro bono practice at Cleary Gottlieb, a big white shoe firm. I don't think I don't think that what we're speaking about on this panel is radical. What pro bono practices many times at firms, and I can only speak from New York City, they are still working within typical financing structures. And even that first hurdle of understanding why this is important, and then the second hurdle of trying to say, no, don't apply precedent, don't apply your precedent, deal sheets to the term sheets to this, deal documents to this requires something extremely different. I think that that's challenging. My most immediate response is to say, pro bono practices are not the place to do this work. But I think that that's probably the most cynical response. I think there could be ways if you're willing to push yourself there and everyone else at your law firm there or your team there, which again, that's going to be an uphill battle. But there are other spaces, right? I think there are bar association committees that tend to be trying to support this work and engage with this work. There's an opportunity to also just get involved. I mean, I was a fellow previously, but I'm doing this work separately on my own right now, right? I'm on a volunteer basis, still supporting the movement that I worked with, but doing it in the way that feels right to me, right? So just because, I mean, there are certain rules against practicing outside of the legal firm that you're in, but then there are there's other research and support you can provide to be involved in this work. That's my cynical response. I hope someone has a less cynical response than I just gave.
Exactly. I'm not sure if he raised his hand with the less cynical, so we won't rope you into that, but a response generally less cynical, welcome.
I would like to encourage everyone listening and participating to reflect on the desire to show up as a lawyer or show up as a professionalized being. This isn't work that is done by lawyers. This isn't work that's done by land trust practitioners. This is being in the world. This is, if you are a human, if you have been constrained by settler colonial law in the way that you have been educated or encouraged, sometimes violently, to lose sight of your earthliness, of your presence, of how it is that you came into being. And so I would encourage folks to think beyond the world that you've been professionalized into when you're thinking about how you can show up to assist with this. Perhaps different than cynical, but maybe not what you were looking for.
And Satish?
Thank you. It's hard to follow, Satya. I can listen to your voice all day long. It's very soothing, meditative, and I want to echo the point that you made, which is, well, first I want to say I work at the Legal Aid Society and we're hiring. So if you're interested in this work, come work with us. We have a tenant rights practice. We have a community development practice. We also do all the traditional things that a legal services law firm does. We're also the public defender in New York City. So just a plug there, we're hiring. But to follow up on what Satya said, I would just add that, as a law student or someone who may be going into the legal field, I would urge you to be aware, be self-aware that in some ways we're going to be part of the system. And I think Akila alluded to this in the pro bono world in a place like New York City. We are, in a way, part of the system. We're lawyers. We are learning the rules as they exist. We don't always have an opportunity to change them. And you got to be aware of that. So every day when I go into housing court to defend a tenant, I ask myself, am I part of this place? Is my client seeing me as they might see the landlord or the judge? And that's a problem. But that being said, with that self-awareness, I think there's a lot of good that can be done for everyday people who are facing these real problems of eviction, of foreclosure, and so on. So that's just my 2 cents on that.
I have a quick, slightly non-cynical view to offer in the sense that federal Indian law is a space often, it is a space for colonization, but it is a space also where this radicalism has been codified into law and where our legal system recognizes this radicalism and allows for it, such that institutions like large law firms, in particular the Jenner and Block Supreme Court practice with pro bono practice, with whom the Sovereignty Project that I run works, for example, helped litigate McGirt v. Oklahoma, which is a case where the Supreme Court held just a couple terms ago that the implications are such that one half to 2/3 of Oklahoma falls within the jurisdiction of majority, minority, indigenous communities, and is removed. So this world of where we have land trusts, just envision Oklahoma as now a land trust in many ways. It's a complicated fight, but it also allows these institutions that don't recognize radical action in other contexts because it hasn't been codified into law in the way that it has in the context of federal Indian law, but it does allow that practice in all sorts of spaces. And so there is an avenue for formal legal engagement through our very conservative system and conservative institutions, and a space where law already recognizes the disempowerment of communities of color, of historically subordinated and marginalized communities as a legal injustice or a legal wrong that should be remedied by courts, by legislatures, and by the administrative state. And so there is a space for it, but it seems as though these other fights are in the timeline, are on the less formalized, radicalized side than Indian law at present. And there are things to learn from both. And so, of course, you don't want to get lost in one or the other, but the less cynical approach would be, try to incorporate Indian law in some context, as well as to start to foster these practices on both sides, because they seem to have a lot to learn from one another. All right. So I think, do we have time from our organizers for more questions? We have a huge list of questions, to be fair, from our audience. It is fantastically long. There's no way we could get through it, but do we have time for one more question, or should I end it here for folks, the powers that be, that police our borders?
Let's do one more question.
Okay, great. And should I just do 6? Let's see here. Oh,
sure, let's do it.
Oh, or maybe 7. The 7 looks very good. Okay. Can anyone address land conservancy and colonialism in relationship to the use of CLTs as a tool to move into kinship sovereignty systems? I'm sure there's going to be a cynical approach, which it should be, but both answers welcome.
I would like to respond to this, but I would like Leah to join me and perhaps provide a context, and then I'd like to deliver a pearl, if I may.
Oh, glad to. So yeah, I guess I would say I'm on the cynical side of this question. I mean, conservation has been historically been a colonial white supremacist endeavor. The enclosure of lands for the protection of nature, for privileged access to hunters in Africa, the creation of national parks through dispossession of native people, the continuation of enclosures from the past to so-called green grabs today. Conservation has been a very treacherous space, particularly for indigenous peoples whose traditional land use practices have been often maligned as supposedly destroyers of nature's diversity. Case in point, pyrogenic landscapes, controlled fires, prescribed fires, for centuries being maligned as destroyers of lands and diversities, only to be found to be actual fundamental keystone players in maintaining ecosystem diversity to this day. And so, fortunately, over the course of time, progressive research in different fields has helped to foreground the importance of these practices to new forms of conservation, but we are definitely not past the treacherous spaces where different conservation schemes continue to be factored into systems that reproduce capitalism, which in turn destroys biodiversity at a large scale. Case in point, compensatory afforestation, biodiversity offsetting, other kinds of enclosures that continue to play a role. Big greens today continue to be complicit in these ways, and it's a treacherous space for indigenous peoples who oftentimes have no other way to push for land titling and land demarcation than through ways that are tied to conservation. As to how that plays into community land trust, I'll let Saka speak to that. Now, I will say that there are ways in which different forms of land rematriation for indigenous peoples does move into restoring dignity. But that path of restoration of dignity has to be very cautious, not to allow sort of romantic appropriations of indigenous peoples as mere caretakers of land, but as opposed to that as sovereign peoples who have a right to decide over their lands according to their own needs and uses, and to not be incorporated into these larger schemes that maintain the reproduction of capitalism in the state. So I'll give it off to Saka at this point.
Thank you, Leo. The thing that I'd like to offer is a moment of recognition that with the various uprisings, the political consciousness has shifted. There's an awareness by the settler state that there's a desire amongst brown and black persons, people of color, to achieve a bigger seat at the table, as people say, or have their voices heard and their needs recognized and addressed. And one of those ways has been to create a lane for those who are interested in pursuing community land trusts or other types of institutions. And what we're seeing is that once that lane has been created and resources are channeled into that space, that we are expected to stay in that lane and let business continue as usual. So what I do have a very cynical relationship with community land trusts. I try to share with folks that the community land trust is not the solution. It is not the solution. It is an institution like any other, and if it is not grounded in a proper context and proper relations, then it falls to the support. It falls to support white supremacy. That being said, any opportunity that we have to make a claim and to complicate existing frameworks and advance an alternative is a useful opportunity.
I think we have gone over time, and that I think is a wonderful note to end on the complexities, but also promise of the work of our panelists and the lessons that they offer from their practice and theory and real world engagement. But with that, please join me in thanking our panelists, and I believe our organizers will move us on to the next stage of our conference. Thank you very much.
Thank you.
Thanks to everybody for having us.
All right, thanks everyone. Thank you, Professor Blackhawk. Thank you to the leading lights on this panel. There are so many mic drops. Our editor's thread is just a Twitter with so many quotations from the talk. I will give my team in the back, Will, a chance to get the final slide up, and then I'll say some thank yous and I'll get us out of here. Thanks, Will. So first I'd like to thank my team at ELJ, Brittany, Tanya, Will, as well as our current staff and board and last year's staff and board who have been champions of this work for the past 2 years now. I also like to thank my professors who were with us earlier today, Professor Gillette, Professor Korngold, people who's really shaped my thinking when it comes to land, law, and social justice. I'm also grateful for my colleagues at UHAB, Klein Hornig, the Furman Center, my comrades from Cooperation Jackson, and importantly, I want to thank my partners in this work, Center on Race and Equality in the Law, Jason and Christine, and the leadership at the Office of Global Inclusion. Without them, this symposium would not have been possible. Just 3 reminders for our audience before we end today. 1, be sure to complete the CLE form. I know there were some issues getting access to the form earlier. We've dropped links in the chat. If you have any additional questions on that, feel free to email me with the address on the screen. 2, we'll be publishing a special issue of ELJ celebrating the visionary insights of our panelists. Everyone you just heard speak will be publishing a short essay that gives us a deeper view into their work and into their reimagination of legal dogma. So stay posted for that. You'll receive it via email in the coming months. Finally, I'll share that if you have any questions on Free the Land. If you would like to get in, if you'd like to submit to ELJ, if you'd like to partner with ELJ, if you are inspired by the remarks you heard from my colleague Tanya earlier about ELJ's focus on an expansive environmental justice agenda, please do be in touch. We'd love to learn more about you and look for synergy. With that, I will conclude Free the Land. Thank you so much to everyone who spoke with us today and who attended today's event. You are the folks who made this work possible. All right, good afternoon, everyone. Bye.